Tucker is his name, and his life is not the same since the wrongful dawn arrest while he was down in Key West. Matthew Bonnet lost his life by the stabbing of a knife, and in Treehouse County shack two assailants did attack. The main suspect for the crime only served minimal time. Travis Johnson took a plea, and Rory Wilson lost the key. All the evidence in court was from a witness that was bought. Paula Belmont testified, but the court felt justified to charge Tucker with the crime and waste 2 years of his time. It was down in Monroe County, and $2 million was the bounty, so he spent 2 years in jail until Oren posted bail. As pro say he would defend his innocence until the end. And Judge Jones, with all his fury, got upset by hung jury. So the prosecutors filed, but they want another trial. They disqualified the judge, cause they knew he held a grudge. So Judge Morgan takes the case, and conditions are put in place. So when Tucker missed the test, he served a warrant for his arrest. 3.1 is now the bounty issued out of Monroe County. Crooked cops put him through hell, locked him up in a jail cell. Now they claim he tried to flee. Won't you set poor Tucker free?
Hello. Good morning. Good morning. Sorry, I'm rolling up on this chat. We've got 3 miles of chat to go through. Sorry for the delay, folks. We're here now and we're ready to deliver. And as promised, our special extraordinary guest of the day, Mr. Stephen Askin. Hello, welcome. Can you hear me?
Yeah. Hello. How you doing?
Muted.
Yep, I had it muted. Trying to keep the dog from intruding.
Yes, I had to feed the cats before I got on as well. How are we all? We're all good? Having a nice weekend, I hope. It's early Saturday morning there for you guys, isn't it?
It is. Yeah.
We've got quite a few people in, which is excellent. The more people, the better, to get this story out and get it back into the mainstream media, because Mr. Tucker needs our help.
He does very much. So
we've got a few updates from the last 2 weeks, basically, and there was a motions hearing yesterday, but unfortunately there's no documentation that's come out from Monroe County Clerk's office as yet as to how that went. We have a few ideas on what has gone on, which we'll elaborate on later. But welcome everybody, and thank you for joining us. So, where was I going to start? Do you want me to do a bit of a case overview, or do you want to jump straight into the docs? What would you like to do?
You can do a bit of a case overview just to make sure anybody that picks up on this that isn't familiar is familiar.
Yep. Beautiful. So anyone who hasn't has been living under a rock and hasn't heard of the Treehouse murder trial, Franklin Tyrone Tucker is the defendant's name. Now, back in November 2017, Ty was living in Key West, Florida, and there is an establishment there called the Treehouse, which is known for ill repute, basically. And 2 masked assailants entered this venue and for a botched robbery, basically, and held the occupant at knife point, who was Paula Belmont. And she had another gentleman there, Roger Rago, who was knocked down as well by one of the assailants, and they basically robbed her. And then with the noise that created, this treehouse was above a trailer park, and the landlord of the trailer park, Matthew Bonnet, came up to investigate as to what all the commotion was about, and basically was intercepted by the 2 assailants exiting the premises and was unfortunately stabbed at the time and lost his life. So where Ty comes in, well, later that night, we've got body cam footage of the police doing their investigation, and they had their two suspects right off the bat. That was Rory Wilson and John Travis Johnson, straight up. And so they were the main suspects, and they were put under surveillance. So the next day, John Travis Johnson was seen walking with Ty down to get their mobile phones recharged. And so then Ty became a person of interest because he was associated with him. They had a look at his Facebook page, and Ty had recently been to a Halloween party and was in costume and had a photo of himself up there with a fake knife on it. So he was brought in for questioning, and it went from there, basically. So he has been wrongfully accused and charged with the murder of Matthew Bonnet. There is absolutely no evidence whatsoever to support the state's claim of this of these charges. No DNA, no IT data, nothing whatsoever. And throughout, from the very beginning, the state have made it very obvious that they are shady, pretty much. And because start again. So once all the charges were laid and it went to trial, Ty decided he was going to represent himself as a pro se defendant. So it went to trial. He defended himself, and it was a hung jury. So once the trial was ended, he was released on bond, and he subsequently opened his own YouTube channel and decided to post all of the evidence and all of the happenings that had occurred to him from the beginning. And it had allegations of judicial misconduct and evidence tampering and all manner of things by the state, and they didn't like that. So they tried to find any way they could to shut him up. And eventually what happened was he was late for a random UNA screening, which he actually did attend eventually and passed. But because they wanted him back in jail where he couldn't say anything, the judge issued an immediate bench warrant for his arrest. And as he was on his way back from Oregon to Key West to surrender, they arrested him at the airport. And so he is now sitting in Munroe County Detention Centre awaiting trial again, which is happening on the 6th of September. So it's getting closer. So there is a whole gamut of things that happened within that, like the judge recused himself and a new judge has been appointed. And yeah, it's a rabbit hole we can go into, but we're taking up from pretty much the end of the last trial and the proceedings since, which they haven't been broadcasting because they're trying to limit the amount of information that's getting out into the public, which is another way of gagging him. So they've been pretty darn underhanded. Actually, what I'll do, Steve, I did a little quick trial clip presentation just to show a few of the shady stuff that have happened since then. Just give me 2 seconds and we'll watch this. It's only a couple of minutes.
Sounds good.
All right.
Among other things,
who's that?
The closing argument of Prosecutor Mansfield is just a minefield of mistruths and untruths and just absolute twisting and turning of facts.
How does he know Matt's blood's going to be on that knife?
I'm sorry, Mr. Tucker. Once again, you're stepping on somebody when they're speaking.
Because he was there. He knows where that knife went. It went into Matt's back. That's how he knows. He knows that knife is not the one that was used on Paula. He knows that knife is the one that was used on Matthew Bonnet.
It's particularly terrible is what he did when it came to this issue with this knife that he claims that Tyrone Tucker told Paula that there was Matt Bonnet's blood on a knife. So
But what says, okay, what says I'm carrying that knife? What says that I'm using that knife? Nothing. Now, again, I'm not trying to mislead anybody. Well, he can't even prove any of that. You can't prove I was there. You can't prove that I actually committed any crime, that I actually did anything, that I even discussed a crime with them. You can't even prove that.
That's not how we do it. So, okay, so don't do it.
There's not a single piece of evidence that Mr. Mansfield actually put to me. Not one.
And yes, I do know that I'm being set up because, or that, yes, I'm being set up for this because I'm here.
Right.
You would know better than anybody, Mr. Mansfield.
Oh, would I?
Yes.
But I wasn't there. You were. So why don't you tell me? Are you telling me?
It's an example of what happens when a state attorney has nothing and they do what he did. And it's absolutely terrible.
Judge, we would just ask for the court to reinstate the gag order. There's been so much out there that when we retry this case, we're still going to have to get a jury from this community to the extent that we can limit now the information that's getting out there. I know that it's absurd how much attention this case has gotten, but we are going to have to pick a jury again from this community. So I'd ask this court to reinstate the gag order in order to assist us in the endeavor of doing that in a couple of months. I
plan on using for this cross-examination is an IA report from this case where it was sustained that she mishandled 35 pieces of evidence in this case. And again, these are including videos. So I would consider that highly relevant.
I mean, I guess we'll get to it, but I don't consider it relevant. If there's some showing of a tainted piece of evidence or a chain of custody that's been compromised, but this, it's not, the trial is not about...
Your Honor.
Yes, sir, I am speaking. The trial is not about putting the investigation on trial. It is specifically the facts and circumstances. So as I said...
Well, don't know how that bit got in there. Bad editing, Jody. Yeah, so it was just sort of trying to give you an idea of how biased the state and the judge were against him and how badly he was treated and just the absolute rubbish coming out of their mouths through the trial. And good morning, Elizabeth. Sorry, didn't miss you. And I mean, it's endless. There's every person from the prosecutorial team to the district attorney to the judge, all the way up. It's a shit show, basically. So,
It is.
yeah.
Yeah, it's definitely a mess down there. But I think it's more than a shit show. I think it's a situation where there's a willful attempt to try to railroad an innocent man into prison, and that's what's going on down there. And that's because they don't want to admit the mistakes that they made early on, and now they're kind of stuck. And it's the concern I have is going into this trial is now I'm happy to see the most recent motion in limine that was filed by Ty, because that was something that is actually one of the best motions he's filed, because he's raising issues of the behavior from the first trial, and he's asking the judge to prevent that behavior in this trial, because what we know, or maybe he'll change his approach, but I don't think he will. What we know from the last trial is Ty didn't want to object because he didn't want to be seen as trying to block something from coming to the jury, et cetera, et cetera.
Well, he was getting told off by the judge every 2 minutes as well.
Well, one of his strategies, which I disagree with, because was he was trying to he was intentionally not objecting and intentionally not trying to keep things out. His opinion was, I want to be seen as like letting it all in. And that's one of my issues. That's a great strategy, but then you got to close on that. And he didn't close on that necessarily as strong as he needed to.
But you need to preserve the record too, don't you?
Well, that's the downside, is because what he's doing is he's gambling that he's going to be found not guilty, but he's got to take advantage of the asset in the room, which is not the fact that he's got the best lawyer in the room. In fact, he's got the worst one. He needed to be able to stand up there and tell the jury, I'm innocent. He's got to break the rules. He can't let the judge break him down like we saw what happened in the closing arguments in the last case, where by sidebar after sidebar after sidebar after sidebar, Ty needed to look like the guy. I'm an innocent man. I got nothing to lose, and I'm telling you, I'm innocent. And I don't care if I'm breaking every rule of decorum in this courtroom. I'm innocent. That's why I'm standing up before you, and I'm telling you, I have a unique perspective. And do everything that the state asked, because the state filed a motion in limine last time that said, hey, Ty can't proclaim his own innocence. He can't do X, Y, and Z. But once you get to the closing argument, he can, because once you get to the close, the case is closed, and then the state has to decide: do they want to have a mistrial? I mean, now, in my opinion, I think the only thing they were holding over Ty's head last time was if it ended in a mistrial, they could revoke his bond. I mean, that is one thing the judge could do. And when Ty was late for court or misbehaves in court, bond could still get revoked, and he could still be remanded into custody. Well, now he's in custody. So now he's truly fighting for his life, because he's no longer free. So I hope this time when he shows up and he goes to close, that he just lets it all hang out, that it's there's no decorum anymore. This is just, state, you want a mistrial? Fine. Give me another mistrial. But this is how it's going to go. And I'm going to be talking about whatever I need to talk about. And I'm going to let this jury see an innocent man, not do the disastrous end to the close where he actually says to the jury, you can believe me if you want to. What are you talking about? You don't have to do that. No, he needed to be saying in a strong, firm, affirmative way, I'm innocent. Like, I'm here to tell you what it is. Like, I understand you might not know what it is, but I know what it is. There's one guy in the room right now who knows who's innocent and whether I'm innocent or not. And I'm standing before you, and I don't have attorneys around. I've let everything come in because I'm an innocent guy. There's nothing they can do to me. The evidence you've seen is all manufactured, or there's issues with it because there isn't any evidence. I mean, there really isn't.
The burden's not on him. He needs to focus more on creating reasonable doubt than proving his innocence.
This is the problem with the divergence of strategy. His attorneys have told him in the past, from my understanding, that was the approach they wanted to take, and for good reason, because there isn't evidence there. There's a lot of reasonable doubt. I mean, the reasonable doubt exists in this case. I mean, it's unbelievable. But he doesn't want that to be. He wants to argue actual innocence. He wants to say I'm innocent, and he wants to get into all these areas that he's not necessarily allowed to get into. And by going into those areas and asking the jury to say, well, I want you to find me innocent, and I want you to find that these people are corrupt. If you can't bring in that evidence and the judge keeps it out,
it's two separate.
You sound like it hurts your cause. Let's put it that way, because you're right. The strongest thing here in this case, and this is where it's such a concern, is the beauty of the reason why the American justice system is unique and is the greatest justice system in the land, in the world. Right.
Not if you ask Ashley Benefield.
Well, that's correct. But Ashley Benefield still got the benefits of the justice system, and she will continue to get that as she moves herself through appeal. But the presumption of innocence is what, and again, I want you to go back, and this is why one of the things that's frustrating, that, like, for instance, when my dad would watch a trial or be viewing trials, whenever he would do it, we'd be watching a case or something, is the way he would see the defense attorneys stray away from the presumption of innocence and the burden of proof. And a lot of defense attorneys think that's like, well, if we start talking about that, juries don't like that, but that's the equalizer.
Mhm.
The fact that they don't get to walk in. I want you to go back and watch the openings and the closings of that case, and I want you to see what wasn't discussed. I want you to see how the defense had a burden, no question, but it's a little different. But you didn't hear that defense attorney explaining it. You did not hear them talking about. I mean, what should have been. My dad used to lay it out, and he would say, think of reasonable doubt like a number line, right? You have 100 numbers, left to right, and the state has to get to 100.
Yep.
If the defense is anywhere from 1 to 99, it's not guilty. Whether you're at 99 or you're at 1. In other words, whether there's 99, you have 99 reasonable doubts or you have 1 reasonable doubt, it's a not guilty verdict.
Yep.
So,
Absolutely.
so if that jury believed Ashley Benefield, again, the only burden the state had or the defense had was to get the instructions to be able to argue to the jury that self-defense, how they could conclude self-defense, whether it was self-defense in the moment with only what was going on in that apartment at that moment,
Mhm.
or it was self-defense, or could they draw in the last 3 years or 5 years or however long she was involved with this man and he was abusing her? Could they consider that her mindset was affected by all of that information? And then she feared him because of all of that. But if the jury had even one doubt as to whether or not that factored in and self-defense happened, they don't have to conclude beyond a reasonable doubt that self-defense happened. They just have to think it could have been self-defense. That's all they had to have.
Yeah.
But
I don't know how they didn't believe her.
well, because
honest,
again, the number one, this is again, they had 6 jurors on there. Now, here's the amazing part. I don't know if you guys knew what they had 6 jurors. 5 were women, 1 was men.
Yep.
1 was a man.
Yep.
So you had 5 women on that jury that looked at the situation, and I guess they just didn't believe her. I think that's what it came down to, and they just flat out did not believe the story she was floating.
Yeah.
I think the hardest thing in a case like that is this, and this is what I heard a lot of people talking about in the chats and across the way, and even when you look, the prosecutor just had an interview. It was the fact that she let him come to the house. She let him come to the house and let him come in there, and people have a problem with the fact it's like, well, you're going to claim he's abusive, but you let, there's a difference between dealing with child custody issues, but then when you're inviting him to the house for something that has nothing to do with child custody, you're like, come help me move. And then you come in, that was a problem. So then they said, well, that's why I think there was obviously some on the jury that thought, they were somewhere in the 1 to 99. And then you had some that were firmly on the 100 side, and they compromised. So,
and unfortunately, I think he invited himself and she didn't stand up for it.
Well,
and that's a common occurrence when you've got someone who is so controlling.
Absolutely.
And that's part of the abusive cycle.
It's to get along.
If you haven't been there, you haven't experienced it, so you don't see it.
Well, that's the problem, and that's why I say, I think it's interesting. I thought it was very interesting that the same week as the Ashley Benefield verdict, we had the sentencing of Chris Greger, and talk about contrasting 2 cases that are similar. In the Chris Greger case, you have a father who has money and means, re-enters the child's life. He's abusive to the mom. He's, there's all sorts of stuff that's going on there, right? And nobody believes the mom. Why? Because she had a drug substance abuse problem. Nobody believes the mom, and the child ends up dead. And if you go into that case and you look back and you see where the family of the mom was screaming out, her family and everybody was on Facebook. I mean, there's overwhelming amount. She's trying to work with DCCP, all this stuff. And then you have this case with Ashley Benefield where she goes, she's like, okay, I'm going to go along, right? And that's what she's doing.
Play the game.
She was doing the same thing that the mom in that case was. I mean, the mom in that case was staying at the apartment. Now imagine if the mom in that case would have killed Chris Greger, they would have gone after her and said, hey, you were staying at his house, you were doing all these things. And the thing is, nobody believed her until the child's dead. until he's showing up at the hospital with an unconscious
Yep,
child
yep.
and fleeing to Tennessee. And
And
everyone's
she would
like,
have been staying at the house to protect that child.
that's right. And the thing is like Ashley Benefield goes down there, and we have a court system that's ignoring her pleas
Yep.
for help, ignoring
Yep.
everything that she's doing. And now we're going to go lock her up for 30 years. She survives the
Yep.
man. She survives the attack. He finally puts hands on her and
Yep.
punches her.
Because he knew it was final then.
Well, that's the point. That's what I mean. And that's why I
Yep.
really I couldn't believe the prosecution in the case. Now, again,
they were rotten.
they were. I mean, the only thing I can think of is that sometimes there's things that we don't see that they must have been privy to, but I cannot imagine how they justify that. But I watched their interview. They were they're like, this is in fact, what they were saying was, it was kind of interesting because it was something, even the defense attorney said he'd never seen it. And it was amazing how you saw the evolution of the state's case. And in fact, that'll be something that comes up on appeal, because the state is arguing one theory to the jury, right? And when you put forth that theory to the jury, that's the theory that's got to be evaluated. Mid-trial, they adjust the theory and say now it was no longer about her feared exposure in the reports, because they figured out that wasn't even happening for like 10 days. Now it was about getting custody, and that there was this date coming and she needed to lure him in.
Coming out. Yeah.
Well, they dropped the report. They changed it.
They impeached the witness.
Right. But that right there is something that, for them to be allowed to do that again, the defense attorney needed to communicate that to the jury, and he did. But that alone could be a potential, when the judge was evaluating this thing, and say, wait a minute, the state comes in with this theory. Now they've changed it mid-trial. They've changed what the theory is. That alone is reasonable doubt. That alone questions the basis of saying, well, wait a minute, how do you go from you've had a multi-year investigation, and now all of a sudden mid-trial you decide to say, well, now she's doing it because she didn't want him to have custody anymore. She wanted him to be part of it. Well, he's been part of this for a couple of years. I don't think that's it. I mean, I think she was frustrated, but I think there's something else going on here. I think it's that, basically, to me, the strongest point in that case was the knowledge in his mind that they were going to be, you're right, court had an issue on it, an impact on it. What he knew was happening was motion. It had already been all but filed. He'd gotten the confirmation that the protective orders were getting lifted, that he wasn't going to be blocked anymore. And all of that had been in effect for all the years they'd been in Florida. They'd been litigating. And the litigation was ending, and they were going to Maryland. And what I believe was happening is he said, it's time you start becoming a wife. It was like, now we're done playing. And here's the thing that's so egregious. I don't understand how these prosecutors can look at a case where he was the same way with a previous wife.
Yep.
So he had a history of abuse. It's like, it's like looking at the Chris Greger case, right? People say, well, the treadmill, they try to justify. A lot of people don't realize that the treadmill incident happened before multiple times. In fact, DCCMP was involved, telling him, don't put your kid on the treadmill. And then he puts him on the treadmill 12 days before his time. Yeah. And the human bite marks. They were complaining about that for years. What do you see in the treadmill video? He's biting his kid. That's corroboration, unlike what Mr. Mansfield considers corroboration. But the whole point is that's corroboration of what was going on, of what the mindset was. And the bottom line is that's the trigger point to me. So he thought, you know what? Yeah. Now, I'm gonna do what I did.
I'm losing control.
And I'm going to
what upset me, the prosecutors are there to present the facts of the case, not to bully and enjoy what they're doing. And that really got on my back,
Well, that's what I've said in many cases, is the state loses. Like, for instance, I was talking about this in the Nicolay Mew case that just also came up for sentencing this week. And the prosecutor in that case was lost track of, in my opinion, what his purpose was. And, you know, the state is not there to win a case. They're there to present
the facts.
that. And again, this is what I was making a point in one episode I was doing, is I said, if you on Apple TV right now, they have the it was a movie at one time, now it's a show. It's called Presumed Innocent. And I think it was really highlighted in there because the prosecutor in his opening statements telling the jury, we're here to deliver justice to the victim and figure out what happened. If we don't have this trial, we will never know what happened. I said, wait a minute, hold on. What are you talking about? A prosecutor is never there to figure out what happened. They're supposed to already have it figured out beyond a reasonable doubt. The police are the ones that figure it out. When you're in trial, you are presenting the evidence that has already been found to show that you have proof beyond a reasonable doubt that the defendant committed the offenses that they're charged with. And then
that's why I put in that comment by Judge Mark Jones that the trial wasn't to investigate the investigation.
Right.
It's all part and parcel.
That's exactly right. That's exactly right. And it's, you know, the point of a trial, like you said, and then in highlighting that comment, the investigation is what is the trial. That's what it, you know, and now he was saying, well, the investigation itself isn't relevant. It's what emanates. Yeah, but it is the investigation itself, because if the investigation was shit, then the stuff emanating from it is going to be
shit.
Yes. So you can't you can't say that the way the investigation went isn't part of the trial. Now that I understand there are some things that get litigated, there is, and you kind of deal with all those things. What's admissible, what's not, and all of that is dealt with leading up. So some things can't come in for particular reasons because it might be hearsay, it might be something that's not relevant, it might be too prejudicial for the jury to hear. So the judge is a gatekeeper in that sense, and you can't just bring things in without establishing a foundation for why the jury should trust it. And these are the little nuances that Ty Tucker is going to have a problem with when especially now that he has no access. He's not going to have, remember the first case, he was actually texting.
I've got the link of the entire first trial in chat right now. So
okay, good.
Go back and have a look and watch the whole trial. Go
on. Remember in that first case, he had a cell phone that he was texting the entire time to his advisor. I think it was Jerome, that he was able to have access to. So a lot of people say, oh, he's on Facebook, he's doing this. He probably was a little bit, but what he was really doing was there were times in that case where an issue came up and he was texting live time to say, what do I do with this? And the judge allowed that.
Yeah.
He doesn't have a cell phone this time. He doesn't have access. And as far as I know, they're not going to let an advisor sit at the desk. So it's going to be very difficult. Like they're going to run circles around him like they did. And if you need any proof, then you just see the way Ty waived the speedy trial. And Judge Morgan walked him through that
hearing.
Yes. And that's why I've said Judge Morgan's goal in this case is to walk him in and get him to waive away everything, so that when the verdict comes down, if it's a guilty one,
there's no appeal.
There's no appeal. He's done. He's in a cement box for the rest of his life. In the sweltering heat of Florida. And that's going to be that's the concern I have, is with Ty not having a lawyer. And the thing is, and then now, okay, the dangerous thing he's just done, okay, is, and again, make no mistake, you know, and again, maybe I'm jumping to get into this, but when he filed for indigency, which is what led to the attorney originally being appointed, it was a civil indigency, which they knew, but they took this opportunity to appoint him counsel so he
cover their ass.
Well, it allowed for him to re-waive counsel, because one of they've now taken away probably one of the biggest potential
Appellate issues.
Appellate issues, which was they revoke his bond. He's now mired in a divorce with his wife who had the finances, and now she says, well, we're not together anymore, so I'm not in, all the assets are frozen and there's no money to hire an attorney. So now he's stuck down in Key West, no attorney, no family, no nothing.
Yep.
So what did they do? They presented him with an attorney. They appointed 2 different counsels who conflicted out, and then he had just gotten appointed a counsel from, I think it was, I can't remember the location where she was from, but she was from outside the Key West area.
Regional.
No, this was the regional got conflicted out. That was it. That was Zanubi was the guy that came in for regional. He got conflicted out because regional represented Rory. He got another counsel, private counsel, who had to come in because, see, once you go through, if PD conflicts, if regional conflicts, now you have right to private, like a private attorney can come in and get appointed. And a lot of attorneys will do so many appointed cases a year, so they'll be on a list. Some of them they do it
that
because
Marla Levinstein.
Yes, that was her. And basically, a lot of people don't realize this fact. My dad would tell you if he was here that a lot of people who try to do just criminal defense, they don't make a lot of money because criminals don't have a lot of money. I mean, unless you're getting the rich people, but a lot of them don't have a whole lot of money and they don't always pay. So you can charge them whatever you want an hour, but when that bill comes, you know, you're going to get whatever they have, and that's that. And you can decide whether you stay in the case or not. So a lot of people that want to do appointed work or want to do criminal work, they end up doing appointed work. There's several young attorneys that my dad began helping out throughout his time, and their practice had just absolutely whittled down to where they had 6 appointed cases, and that's all they had, and they were struggling. And he came in and helped to attract cases their way and help them out. So a lot of attorneys, appointed work, it's easier to, you can get a quality attorney sometimes through the appointment system because some of these attorneys are literally, it's the only way they're getting paid work. I mean, they could get people that want them to represent them, but they don't have the ability to pay. So they go in and get appointed. So he had the opportunity. So what have they done here? They gave him a privately appointed attorney, and he waived them and he fired them. And that's what happened yesterday, because now he went, or I think it happened on the 1st, and he clarified it and said, I filed for civil indigency and I don't want any help from an attorney. And that is now a dead issue now. He cannot go back. You cannot raise ineffective assistance of counsel if you're representing.
Should we go through the motion of limine that he submitted? Is that?
Yeah, that's fine. We can do that.
Place to start?
Yeah, that's a great place to start.
Yep. All right.
Yep.
Let's do it. I'll make that bigger so we can all see it. All right. So you've read through this. This is
I have
the motion in limine from Ty. Do you want me to read through it?
Yeah, you can read through it. I mean, if you want to, that's
Can
fine.
you all see that clearly? All right. So comes now Pro Se Defendant Franklin Tyrone Tucker hereby requests this court to exclude the following evidence and testimony from trial. Additionally, the defense would request that courts consider barring the state from using the used terms or phrases that we were allowed in the first trial, but the defense fees are highly prejudicial, in some cases derogatory and irrelevant to the charges at bar. Testimony and evidence to exclude. Number 1, any and all previous testimony or statements concerning the defendant's knowledge of the victim's blood being on the alleged murder weapon or how that knowledge was obtained by the defendant. This request is being made by the defense to keep the state from committing fraud. I can't read that. The court and or jury as they did with the first trial. Specifically, the state in their closing arguments told the jury this: the single most compelling piece of evidence in the entire case was a conversation that was between surviving victim Miss Paula Belmont and the defendant, where He told her it was the murder victim's blood on the knife, and there's no possible way he could have known that unless he had been there. The state went even further by saying, we know for a fact that the investigators didn't tell him, which is rubbish, Malone did, or was it Phelps? And they didn't even send out the DNA for months. The problem is these are all blatant lies. A, they knew for a fact the defendant was told by the investigators when they interrogated him the night prior. B, there is absolutely no way this was harmless error, as the state had video of the defendant being told whose blood was on the knife. C, due to Judge Jones's extreme bias against the defendant, even after being shown the video, he refused to correct this lie and allowed the jury to deliberate, believing it was true. D, not only should this case have been immediately dismissed with prejudice by the original judge, the fact that he allowed it to go back with the jury could have cost the defendant his life. It's ridiculous enough that the defendant is still facing trial after such forgeries misconduct, something like that. I can't read it. Sorry.
No, sorry. It's such a egregious misconduct.
Oh, okay. Thank you. It's
Yeah, never.
it's a crap coffee.
Oh no, it is. It is.
And the judge, by therein, is no way this
Lie.
lie or anything even coming close to it should be allowed a second time. 2, the photos from social media that are not directly related to this crime. This request is because the state, both prior and during trial, either attended or did introduce several pictures from social media strictly as prejudicial material that was irrelevant to the case at bars. Specific photos to be excluded. A, defendant's profile picture from Facebook taken during Fantasy Fest, which depicts him holding a knife. That's the one I was telling you about. Nothing with the photo relates to this crime. It's prejudicial. B, photos from the defendant's Facebook, which depict him in a Halloween costume from years prior to the crime, irrelevant and prejudicial. C, photos from Paula Belmont's Facebook page depicting her trip to California until they insinuated she'd been paid off by Lauren. And any other trips taken by Miss Belmont, irrelevant, prejudicial. 3, any and all photos or physical evidence collected by police but with no proven relevance to the crime. These also include A, any and all clothing that did not test positive for forensic evidence relating to the crime. B, any and all knives not related to the crime. C, the alleged murder weapon. The state's witness, John Travis Johnson, claims to have been the defendant entered the property where the murder occurred with this weapon. However, the state has nothing to corroborate this testimony and, in fact, is contradicted by DNA results from the poll lab, is it? Furthermore, Mr. Johnson has significant evidence to say he was the second assailant and was known by the defendant to be the owner of the knife in question. This makes the piece of evidence highly prejudicial and irrelevant to the defendant, as the state has nothing to back up Mr. Johnson's claims and already convicted Rory Wilson using this knife, as his DNA and the DNA of both the deceased and Miss Belmonte were also found. The state may try, as they did at trial, to use inconclusive DNA results. That's right, yeah. The results were inconclusive, so that means to corroborate Mr. Johnson's story. However, the state is also in possession of an independent expert's report who excluded the defendant from possible contributors. Therefore, photos of the something weapon or the weapon itself offer no material value for the defendant and only act to pressure the jury. The mask allegedly worn by Rory Wilson, no ties to the defendant. The backpack and its contents belonging to Miss Paula Belmont, notes to defendant other than story by John Travis Johnson, who has found to be in possession of the evidence without explanation and has admitted to trying to hide it. F. Any and all physical evidence removed during the search of the 2nd Street warehouse and nothing of any evidentiary value was received. G. Any and all items recovered from the search of the truck belonging to John Travis Johnson as nothing of any known evidentiary value was found. They've got no evidence. There's nothing. H. Any and all items removed from the defendant at the time of his arrest as nothing belonging to the defendant, blah, blah, blah. 4. Any and all photos from the crime scene, nothing tied to the defendant. True. 5. The security video from Cosma's Marine only corroborates that John Travis Johnson drove to the crime scene and that he took part in the crime. It does not show that he, in fact, was not the second assailant, and there is nothing to suggest that he was the getaway driver waiting in the truck with the defendant while the defendant went inside to commit the crime. To the contrary, this video, in combination with physical evidence found in his possession, other videos, his admissions, his knowledge, witness identification, and witness testimony all say that it is conclusively John Travis Johnson in the video and not the defendant. The state relies only on his word that it is not him and the fact that the video quality is too poor to positively identify anyone solely on the video itself. 6. The state be barred from any scandalous comments, implications, accusations, innuendos, speculating queries, or any other type of false assertions concerning any possibility that the defendant or his spouse bribed any witnesses for their testimony, or that any witness altered their testimony in expectation of anything in return for that testimony. The provision should be enforced with all witnesses, but specifically refers to Mrs. Paula Belmont, who, over several sustained objections, was all but directly accused of being bribed by her testimony with a trip to California by the defendant's spouse. B. This disgusting tactic totally ignored any sense of decency, as the state had not a shred of proof of such an allegation, yet felt it okay to impugn the reputation of both the spouse, a non-party, and the victim in this case, to project this life. A life that, after jury members were interviewed, was found to have cost the defence no less than 3 jurors. It is more than prejudicial. It's disgusting and offensive. 7. Sorry, I didn't realise how long this was. The state not be allowed to use inconclusive DNA results as if they were positives, or state these results in such a way as to make the jury believe they could have been positive results. Prejudicial and confusing. 8. No photos of the defendant not related to the crime. 9. Nothing from the state concerning any statements made by Rory Wilson. 10. In their closing arguments, both sides be restricted to material facts already presented during the trial. The state should not be allowed to ambush the defence with false accusations without any facts in their closing. Now, you addressed something there, Steve, at one point. I remember you saying that Ty got caught up in their allegations and didn't get across what he needed to get across in his closing argument. Can you remember what that was?
Yeah, I mean that's my general issue with his closings, or his closing argument that he gave, was the fact that, in my opinion, instead of him talking about the weakness of the state's case and talking about his points, he got really upset about the Paula. Well, he was upset about 2 things. He was upset that they made the argument about the knife, that he had that there was no other way to know how the DNA got on the knife, and he couldn't talk about it because and this is why even Vinnie Politan, if you go back and you watch his post-trial coverage, that was the thing that Vinnie had his panel talking about, because even Vinnie was like, I don't feel comfortable with what just happened, because the judge literally, Ty brings to the judge and shows this statement that shows that there was another way that he could have found out. The state gets to make this argument. The judge then tells Ty that he's not allowed to talk about the police statement. The remedy for this would have been to say, well, we didn't have a chance. We can't reopen evidence. We're not going to be able to play it for the jury. But I'll tell you what, Mr. Tucker, this is pretty egregious. You can tell them that because remember, Ty Tucker was a party there. He can talk about what he heard or how he found out. He could have testified to that. He could have said, I was told, was there any way if he had a defense attorney, they would clean that up on cross or on redirect and said, was there a way? Were you told? Yes, I was. And then if the state was going to allege that that didn't happen, then the statement is allowed to come in because there was an allegation. Remember, that's one of the hearsay exceptions is information can come in when there is a dispute over facts and there's a dispute over credibility. So it could have come in. But the judge, and this is why Vinnie Politian was saying it absolutely had a path to come in, but he didn't know how to do it. But if he had an attorney there, and the thing is, you cannot use.
I could have prompted him while he was on the stand.
Well, the judge is the one that has an obligation to say, listen, we have a pro se defendant here. So we need to make sure this is done fairly and correctly. So you can't be doing this. Either he should have told the jury, disregard that. That's not something you should consider during deliberations and state. But remember, Alvarez stood up in I believe he was the one that did the final argument. And he stood up and said, this is the single most compelling piece of evidence is how in the world did Ty Tucker know, unless he was the guy that stabbed Matthew Bonnet, that the knife that the police that was there, how would he have known Matthew Bonnet? Because what they were trying to insinuate was that Ty Tucker killed Matthew Bonnet because he was the second guy, and that the knife that would have had Paula's DNA on it would have been on Rory's knife, because Rory was handling Paula and Ty was doing that. But then, of course, the argument is the principal theory. Doesn't matter who stabbed who. And again, that's very important in this case because all the state has to do is say he was involved in any way. So I want that to be also something that, and this is the part that I think that kind of escapes Ty in a way, is listen, let's say, and I've been on a jury. I know what goes on in a jury room, and you'd be shocked with the speculation and the stuff that goes on. And you got to hope that you got a strong individual who says, we're going to follow the law here. You can't go there.
Yeah.
But the state puts this whole case on, and they go, okay, the allegation is these three guys set out. Now, we don't know. Maybe Ty was the driver. Maybe John Travis Johnson went in there. Maybe Rory was. The only question at hand that the state has to prove, which is why they're so confident to go forward, is they just have to prove he was involved in some way.
Yep.
It could even just be that they were planning it and Ty Tucker went to the Burger King and found out about it and said, listen, you two are going to go over there and go do this. That's still under the principal theory he could be convicted. So what they're basically hoping the jury's going to do is that they're going to take a look at Ty Tucker. They're going to look at these guys. They're going to realize that Ty Tucker's living at the warehouse. They're using drugs, and they're all about getting drugs. So it's like you get these up. My understanding
by
is,
association.
well, my understanding is that this jury was older, made up of a lot of retirees. And these were people that would have problems, I think, believing fully that the police are just going to set a man up. So Ty's got to be very careful when he goes in there and starts saying, well, there's this and there's that, because these people are going to turn it off and go, yeah, okay, dude. They haven't seen what we've seen. They haven't seen all the information. These people are walking in for jury duty, and now they got some guy standing in front of them. And of course, a lot of people believe because somebody got charged with something, well, there must be something there.
Yeah, that they're automatically, There's no innocent until proven guilty.
And that's why this case is not as difficult to prove as many people think, because of the principal theory.
They've got no physical evidence. There's nothing.
Right. But all they've got to do, though, is get 12 people to think he was involved in any way, shape, or form. And then under the principal theory, it matters not whether he was the driver. It matters not whether he was the mastermind. It matters not whether he was the one that stabbed anybody. He could have just walked into the treehouse and said, we're going in here to Rory's going to go in here. They could believe there could be somebody back there in the jury room and say, well, you know what? I think that maybe they all got out. Maybe Ty Tucker was already there. Maybe, it could have been that he was friends, because remember, he's portraying himself as a friend of Paula Belmont. Right? They don't understand all the makeups and the stuff. So these people get back to the jury room and they're like, these people were all connected. Paula's saying he's innocent. The state's coming in here and saying, yeah, she's traveling and going on this vacation that she couldn't possibly have afforded. So it's good that Ty is doing this motion, because this is important to keep some of that out. But it's also important to understand that this is not like a situation where they have to go, okay, who stabbed who did what.
Yeah.
All they have to do is think, was Ty involved in any way? And if he was, it's guilty. And it's not as big of a stretch unless you're people that are involved in looking at all the stuff we've been able to see, which a jury will not be able to see. And we surely would not qualify to be on that jury because we've seen too much. But the bottom line is it's a lot simpler path for them to get this done. And that's why Ty needs an attorney, because they need to be able to show that Ty Tucker wasn't involved at all. And Ty needs to, if Ty isn't going to have an attorney, then he's got to stand there and he's got to scream to the high heavens as loud as he can be, saying, I'm innocent, I'm innocent, I'm innocent. I was not involved in this. I was staying there. He told his story, but he's got to say,
his phone didn't need to be recharged.
Yeah, exactly. Right.
Oh my God.
And if he wasn't walking down there with Rory at the moment. But the point is that all points to his innocence, because, I think, again, that's where we have to, what Ty's got to really hammer home. And this is why, to me, okay, I disagree with Ty wanting to keep the Cosme video out. Why? You don't want this jury thinking there could have been 3 or 4 or 5. There's 2 people. Truck pulls up, 2 people get out, 2 people went in. That's what we know. And then, of course, on Paul Belmont's already deceased, but it's important to me that you get in her deposition, and I believe that her deposition, the videotape deposition that was played in court, I believe it was at one point on his website, and then it went down. I don't know where it went, but I swear to God, I watched it.
Oh, there was like 3 of them, I think, or 3 or 4.
Yeah, there was like 3 or 4 of that,
Yeah.
And then they're gone now. I don't know why they went or left, but what I want to know is the most significant thing to me to tie in this case is the fact that when she was at the hospital, she says she heard a car turn on, right? The next day, she's saying she understands that the second guy was JoJo, right? And then you tie in the fact that Todd O'Quinn sees this guy and says, he went in, jumped in, and took off in a truck. And at that point, I think for the jury, that's pretty clear that the second individual must have gone and got into a truck, started it up. So that truck was parked there, turned off. He goes in, and if there would be no reason why somebody would wait in a truck to drive off, unless it was expected that he and Rory were going to be coming there and speeding off, and eventually returning to the truck, to which John Johnson freaks out, runs out, jumps in the truck, and drives back. The biggest thing then is, again, and this is what Ty should be arguing, where is all the videotape? Where's the videotape to show he was there?
Because there was plenty of bloody videos around.
Yep. And
check out previous.
Yep. I mean, and all of that is all, but the biggest problem Ty Tucker has right now is the idea that they don't actually have to prove what his involvement was. They just have to prove he was involved, and that is the standard.
Didn't Todd see him, John Travis Johnson, take his mask off?
Becca Lynn, hold on a second.
Before he got into the car?
Put up the Becca Lynn. He did not see a white guy run towards the truck and drive off. No, the next one. Becca Lynn, go back and watch Brady's interview. It's the very first interview that Todd O'Quinn does. This is the freshest statement. And he clearly says in that interview, as he's talking to Brady, I saw him take off his mask and go and take off in a truck. Ty even asserts this. It might even be, he may have mentioned it in this.
That's why he wants him
He's put it in several things. So it's in there. And that was something that was missed, that they missed. And I found it because I was listening, and it's in there. And that's now Todd O'Quinn in subsequent interviews has said, in fact, he did a deposition with Kara Higgins, and she was, I believe that's her last name, and she elicited from him and asked what was, did you see a truck? Did you see anything? And he says, he doesn't specifically say he doesn't. He just says there's boats down there and there's this and there's that. But the point of it is by getting Todd O'Quinn on, even if Todd O'Quinn says, I didn't see that, now Brady's body cam can come in as a prior inconsistent statement to refresh his memory, to say, well, did you or did you not tell this to Brady? And let me play your words for you.
Yep.
To which now the jury will hear this.
And have doubt.
And then, of course, it's the key to saying, well, again, it's got to be clear here that you've got to tie that in with Paula Belmont saying she heard a car start up at the moment that shortly after the white guy bounded down the steps. And they weren't friends before all this. They established that friendship afterwards, didn't they? Whereas the state were trying to insinuate that. Correct. They were not. Why would a victim testify against an assailant? Well, I think what they were trying to, Becca Lynn, yes, they have. The state has. In fact, this is the issue that came up. Trying to hide him, I think, aren't they? That's the show calls issue that came up. Well, one of this was that they attempted to. They're claiming that Todd is going to be a witness for the state. And that's what they used to block Ty from gaining access to Todd O'Quinn. The gag order as well. Because they said that because Todd is considered to be a victim, currently there's a no contact order. Yeah. And Ty needed to get that lifted like he did with Paula Belmont. The state came in and said, which is absolutely untrue, he's a witness of ours, and he's not indicated to us in any way that he wants to talk to Ty. And the judge went ahead and said, that's fine. We will I'm not lifting it then. So Ty hasn't had access to Todd O'Quinn to try to prepare him for his defense and to try to get him. And yes, I don't think Todd's going to show up. But they gave him the wrong date as well, didn't they? Correct. They did. Yes. They subpoenaed Todd to come for the original trial date, which they had set up for either May or June, and then attempted to use the show calls to require him to come in, which again, as Ty is saying, he's very afraid of the state. And that is meant as Ty is saying, it should be viewed as intimidation because Todd is extremely, again, the state of Florida's locked him up multiple times, but he knows he's very afraid to discuss what he saw. Remember, Todd also, again, it was not a definitive identification, but it was a lineup where he said the closest guy that looks like the guy that I saw matched on that list. He said he's very clear. I didn't specifically see, but if I had to say a guy whose hair looks everything, it was John Travis Johnson. And remember, Paula, and again, this is the shame of Paula being deceased, because again, what happens? You get Paula on the stand and you say, Paula, were you, did you have any belief that John Travis Johnson was the guy? Although it still might not come in because it's considered to be like double hearsay. But you've got the video we all saw where she comes back and says Todd O'Quinn was the guy that was telling her that he'd heard JoJo, because she was with Todd, and she was saying she was with Todd that night, and that he was hearing from everybody that JoJo, who had just come into town, which is true about John Travis Johnson, that he was the second guy, and that was what was buzzing all over the island. And so again, the need to talk to the need to talk to Ty, or not Ty, Todd O'Quinn is huge in this case, for Ty to be able to prepare and try to understand what the testimony is, because what's going to happen is the state's going to object, and they're going to be dealing with all these things on the fly, and the state's going to do its damnedest to try to limit the testimony that Todd O'Quinn can provide.
Mm-hmm. They're just trying to gag him and tie his hands at every possible opportunity, in any way possible.
Yep. And yes, just to clarify what Becca Lynn's trying to explain to everybody in the chat about Ty subpoenaed Todd O'Quinn, but the subpoena was never able to get served on Todd O'Quinn, so they were never able to get a transport order. And that's because they had begun, prior to the trial, moving Todd O'Quinn from institution to institution. And they were moving him around. In fact, at one point, they put him in the same prison yard as Rory, which he had to be requested to get moved off of. As a result, that by the time trial came around, Judge Jones had not signed a transport order, and they had moved him 4.5 hours away. And by the time Ty came up, essentially, there were two issues at that point. All of Ty's subpoenas had expired. So the subpoena that was outstanding that had yet to be served on Todd O'Quinn expired. Ty was trying to reissue it and was saying, well, we're going to reissue the subpoena, and can we either have Todd testify via Zoom from his institution or transport him in? And Jones said, we're not doing Zoom because you can't, you got to have somebody down at the institution, and we can't just do that on the fly. And two, I am not signing the transport order at this point because it would be 4.5 hour drive, and you don't just snap your fingers and put a guy on a transport bus or a car or whatever, and he gets transported to court. Mr. Tucker, you should have had this done before. And Tucker was trying to explain it. Well, I tried, and he basically said, I'm not doing it. So if he's not here, he's not testifying. And then that was part of when Ty got, and he talked about it in one of his subsequent lives, where he said that was a night where he was literally crying in his hotel room because he said, they're limiting my whole case. They've gutted my whole case. Yep. Todd O'Quinn's not testifying. Seth LeVay, they pretty much were killing that because they were making it difficult for Seth LeVay, couldn't come down, and they weren't going to let him go via Zoom, and they were blocking the document from coming in. And Ty didn't really fully understand how to get the document in himself. So he was, he just basically said, I'll rest. And then he ended up not resting because he ended up testifying. So he ended up being, besides Paula Belmont, I think it was Paula Belmont and then himself were his two witnesses that he testified in the trial. Now this time, I don't know if he's issued any subpoenas, but I think he's planning to subpoena and bring in some other people that, again, I don't know when he's planning to issue those, but aren't
they trying to stop him from, or stop the transcript from John Travis Johnson's testimony from the first trial because of Miranda violations apparently now?
Well, the trial testimony from the first trial, that's not the issue. No, what he's trying to do, in fact, the judge has already ruled that the transcript can be produced. So the entirety of John Travis Johnson's testimony has been or is being transcribed, which will then be furnished to Ty, will be furnished to the state. They'll get to review it, make sure that it's all, correct and true and whatever. I think what you're referencing, though, is what Ty wants to be able to do is bring in the suppression motion in order to impeach John Travis Johnson, because essentially when a motion like that is filed with the court, it's being filed on behalf of John Travis Johnson. So it's considered John Travis Johnson's motion. And what's considered herein is a statement to the court that he's saying the statement I gave the police is untrue. I was coerced and my rights were violated. Now, the Miranda issue doesn't really matter to Ty Tucker's case because that statement isn't being used as evidence. The evidence in the case is coming from the witness stand is coming from the witness stand and is what what Travis Johnson is testifying to when he's in court. The statement to the police would come in and could still come in even with a Miranda violation as impeachment, because it's allowed. It's a statement he made out of court that isn't consistent with what he was testifying to. So it's something that could come in. So his testimony in court, the sole issue is whether or not the suppression issue can come in for purposes of impeaching John Travis Johnson and be used as, hey, you went to the court, did you not? And then what happened? You were offered this plea bargain and now you're changing it again. And it's a prior inconsistent statement that can come in, and it is allowed to come in, but it's got to be, but that document has to be brought in properly. It can be brought in by Seth LeVay, but even Seth LeVay wasn't the document holder. He was the producer, and that's the mistake Ty's making. And it's got to come in. It's got to come in. You got to get the clerk of court to testify and come in, and it comes in as a business under a business.
So it's not an easy process.
It is. He's just got to subpoena the clerk of court of Monroe County, and then they come in and they testify before the jury, and all they do is they come in. It's a real quick. These are like some of these witnesses you're seeing in a trial, and they're coming in, they're testifying for like 3 minutes, swear in. Was this certified? Did this come before you? Was this filed? Yes, it was. And this was filed in the court. Yes, it was. And okay, thank you very much. Now the document
to lay a foundation, is it?
That's to lay the foundation that document came in as a court file document.
That's called opening the door,
right.
Is it?
Well, what it is right now. See, this is the disingenuousness of the state in the way they apply things and the way they're doing things. They're arguing. You're correct. The document as it is right now is not admissible. So, if Ty doesn't do the steps to make it admissible, then they can sit here and rest on it. But the problem is when you have a pro se defendant, the judge is supposed to be like, okay, well, Mr. Tucker, I know you're not an attorney, but this is the steps you need you take. Right. This is how we get this document in. Now, I'm not doing it for you. It's not my job to do it for you, but it's your job. It's your job to, go ahead and, get the document in, take the steps to get it in and make this an admissible document. Now, not everything in that document can necessarily come in. There are certain portions that will be redacted, but the portion of it that can come in is the portion that deals with the fact that he's stating that his statements are untrue, and he can talk about that.
I think it was Laurel Avenue, wasn't it? The truck?
Yeah, it was. It was.
Parked,
I think it was whatever the street is.
Laurel Avenue.
Yeah, that you see the
Cosmo's Marine.
Yeah, well, yeah, exactly, because it was whatever that street is. I can't remember off the top of my head either. But if you look at the map, you're seeing. I believe I was told he was parked up by the stop, and I believe if you go back and play his testimony, he testifies that he was parked up by the stop sign. And again, that's what the significant part is. You have to go into the testimony in court. That is evidence, and you take it from there. And you have to look and see. Yeah, but Becca Lynn, what you have to do again. What we're talking about here is how it can be handled in court to provide doubt to the jury. And that's why you put Todd on the stand, and Todd can say he went 2nd Avenue. You can say he went up to 5th Avenue. The point is, when it's the freshest moment in Todd's mind, he's telling Officer Brady that he took off in a truck.
Yep.
End of story. Doesn't matter whether it was 2nd, 3rd, 4th, 5th, 6th, 7th, or 8th. And when that goes before the jury, okay, that means that truck was still there. That means that John Travis Johnson, the story he's telling is that he took off and that he saw Ty running towards him, and Ty never made it to the truck. But Todd O'Quinn's saying that guy left the treehouse and took off in a truck. So it's a matter of then when you put that before the jury and you say, okay, John Travis Johnson. So let's talk about John Travis Johnson for a minute. He was the guy that was accused of being part of this. In
and he's
fact,
already been
and
going to be a liar.
And now he's saying, well, you know, Tucker was involved, and then it becomes significant with how that story got introduced to John Travis Johnson. It got introduced to Penny Phelps. So Penny Phelps walks in and tells him,
2 minutes missing.
"You're no longer the guy in the treehouse. You're the guy in the truck." So where does he get this from? But here's the problem. Moments after, like 45 minutes after this, we have a witness who says that guy took off in a truck, which means someone got in your truck, John. So who was it? Your story is
not. Have a plea deal.
Well, your story is not that Ty Tucker jumped in your truck and you left. The story is you took off in a truck. Todd O'Quinn says the guy took off in a truck. We don't need any more than that. And the point is the defense doesn't explain. The defense just says this exists. And that is the single strongest piece of reasonable doubt that says now the only witness that ties Ty Tucker into this case is John Travis Johnson. And we have a witness that says that he saw someone resembling John Travis Johnson. Can't say definitively it was him, but that it resembles him and did not resemble Tucker. That he then, when you play that prior statement, says he got in a truck. That is why that vindicates Ty Tucker. And that is why that evidence, if presented correctly in court, is what will get Ty Tucker acquitted.
Reasonable doubt.
Because then after that, what do you have? You have a DNA report that is inconclusive. There's nothing that links Ty to that. You have Paula Belmont, which again, if the state wants to call Paula Belmont, let them call Paula Belmont. But at this point, Ty doesn't need her. Ty shouldn't even call her. Because here's the thing. He doesn't need Paula Belmont at this point. Because
Ellen, she passed away in February.
Well, plus he's introducing issues here to where she isn't sure at first, and then she eventually says it wasn't him, and it was this, and it was that. So let's just get away from that, right? If the state wants to bring her in, then the whole thing comes in, and the cross-examination comes in, and Ty can argue to the court that in the end, she eventually said the voice didn't sound like Ty Tucker's.
Yep. Recognizes,
And
John Travis Johnson is not a reliable witness. His credibility has been struck because he lied on the stand and recanted it, his testimony, and you add to that the plea deal that he took as well.
Exactly. And that's why this is an easy case that when you present it correctly and you present it leanly and you keep out all the you don't have to answer questions.
The rubbish.
Right. And the problem that's happening is that the problem that's occurring in the case is that Ty is trying to introduce too much. And when you try to do too much and you start introducing stuff, you kill the case. In fact, I'll tell you a story about how this works in court that I was a part of. When I was in high school, I was clerking at a law firm my dad was a part of. And there was a trial. It was a I can't say it on YouTube without YouTube getting upset, but it was an SA case, we'll just say, and involving a grandchild and a grandfather. Child custody case. It was very messy. So my role was to be in court, take notes, do things, and I was also handling transportation of the expert witnesses. And there was we had a full-throated defense ready to go, right? So we're sitting in court and I'm there taking notes and I'm communicating back to my dad and talking about all different stuff. State comes in and they present this case. Now, one of the things about a case like this is you can't just go say, well, X happened sometime in the last 3 years. You got to have specific dates, where it happened, when it happened, where it was it in the basement? Was it at the mountain house? Was it here? Was it there? Right. So at the end of the state's case, I'm taking notes and I said to my dad, I remember we were eating dinner at a steakhouse and the defense was about to go off. Right. And I said, Dad, I'll tell you what, if I'm at this point, I think I was 16 or 17 years old. I said, if I was trying this case, I would rest the case right now. I said, because
without putting on a defense.
I said, I wouldn't put on a defense. I said, because right now I don't know where it happened at. I don't know whether it was in the basement. I don't know whether it was at the mountain. I don't know whether it was on this date. I said, correct me if I'm wrong, Dad. I think my understanding of listening to the judge's instructions and everything
Mhm.
is that you got to, and he said, well, yeah, you do. He said, so you're telling me? I said, I'm telling you right now. He said, you know what? We don't need to put on a case. And we got up, dinner got interrupted. He said, take it to go. And we went back to the law firm, and everybody came back, and I gave my presentation on what I was hearing. And the decision was made to rest the case. No testifying, because my theory was, or my thought was, if I was sitting on the jury right now and I was asked to come back beyond a reasonable doubt, I couldn't do it because I wouldn't even know when it was.
Mhm.
And guess what?
That's a massive call for the jury. They're like, what? Oh, they're not even
3.5 hours of deliberations, not guilty on all 27 counts.
Mhm.
And and that was the argument that was put forth to the jury. And when the jurors, they said they agreed, they really couldn't, they didn't it was unclear. Now, had they gone on, had my dad and the attorneys gone on and said, okay, we're going to go in and we're going to put the expert witnesses on, and we're going to have, the individual testify. All of a sudden, all of those pieces of confusion, now it's becoming clear because the defense is proving it, at least acknowledging when it happened. So now it's no longer an issue for the jury to understand when it happened, where it occurred. Was it here? Because I'm denying it happened in the basement. Well, okay, now we know it happened in the basement. I'm denying it was over at the mouth. And you're doing that inadvertently because the defense was going to stretch in, because again, it's tunnel vision. They're not looking. You're so involved in the case. You have all these things you think need to be proved, but you're not looking at it from the perspective of 12 people who walk in off the street
I know nothing
and have no knowledge of the case. And that's who's coming in to look at the case, not somebody who's been dealing with this for 7 years, who's emotionally involved, all the nuances and details. They're looking at this as, does the state have proof beyond a reasonable doubt that that you're guilty of this crime? And you got to, and the state gets to come up. And if the state comes up and at the end of their case, it's really weak, well, limit what you're going to put on. You don't need to put a case on just because you're like, again, he wants to put things in for the simple fact that he's mad and he wants to say, I'm going to prove you wrong, and I'm going to show what assholes you were, and I'm going to show how you've tried to frame another day, another time. That's what a civil case is for. But when you're in the criminal case, you're not there to prove anything. You're there to ask questions. You're there to bring witnesses on that might be able to help your case, but you don't go start interjecting things into the case that you don't need to. And all of a sudden now you're bringing issues. It's like when he brought Paula Belmont. I mean, I want you to think about the case that they presented. If Paula's never called to testify, the knife never comes in, the Facebook pictures never come in. One of the things that the judge is going to say in that motion in limine, is correct as it is, that they shouldn't come in. Mr. Tucker, you opened the door. You called her as a witness. You reviewed that. You reviewed it. You knew what was in there. You didn't ask for that to be struck. You didn't ask for that portion because, when you're in, when the deposition stuff was going in, you have a right to go down and say you clean it up, because there were 3 attorneys in there that a questioner. But he wasn't looking at it as what could be done. And I remember Judge Jones telling him, well, Mr. Tucker, you'd be surprised at how they can argue things. I wouldn't be so confident. And the idea there is he didn't go through and look at it because he wasn't looking at it from that perspective, because he's like, well, I'm putting it all before the jury. Yeah, you put it all before the jury, and then they brought that in, and then they were able to argue it, and then you come back and say, oh, it's wrong, but you don't understand it. You waived your right to complain about it because you let it come in. And they gave you the opportunity to cross it out.
Yep. They did the same thing with Karen Reed. Lally put on 60-odd witnesses.
Yep.
And they put on 6. They didn't need to do anything else.
Nope. That's exactly right. That's why a lot of these cases you see out here where the defense ends up doing nothing, because they're falling back on the state's burden, and they're basically saying, we think it's a better argument that the state hasn't met its burden than it is to say, well, we went on and put these witnesses on. And now, again, whether you like it or not, if you start putting on a lot of witnesses, the jury loses track of the fact that the state has a burden to prove something. And they start looking at the defense, and now they're evaluating like, well, and again, like I said, it's that number line where all you got to do is get a juror somewhere in the 1 to 99 and remind them of that and tell them, if you're there, if there's a doubt, if you have a doubt, and a lot of, in fact, in the Benefield case, I thought it was It really, the same thing that I see in a lot of closing arguments bothers me, is where they're trying to talk about the burden. They try to get around the burden of proof, and it's not every doubt. It's a reasonable doubt. It's not a speculative, and that is a relevant. That is a relevant argument, meaning you can't sit back there and say, okay, well, is there a doubt? Well, there could have been a person that came in. No, that's not. We're not
actually quite a high bar to reach.
It is. Yeah. It's that's not what we're talking about. But the state tries to use that to confuse them to say, hey, if you're sitting there and you're like, I'm just about convinced, but I'm not 100% convinced. The state wants them to fall over and say guilty, and not make them have to go right over that, because it's a very high. It's the highest. That's what makes that's what makes the American judicial system special. In almost every other judicial system in the world, there is a burden to disprove the negative on the defensive side. And that is almost impossible. We all know that. Think about when somebody levels an accusation against somebody, and then just think about how groups of people will start looking at that person differently. Even if you're like, I don't think it is, but it's like somebody starts talking, it's like, well, let me hear it out. And then you start hearing it out, and it might be, it's like, oh, and it's just ever so slightly, even the person that says, I don't think they did it, there's still going to be this little change, this little distrust. And if somebody else makes an accusation down the road, it changes it. So when that negative gets it, but the beauty of our justice system, it says you can't do that. When you walk in this courtroom, we do the opposite. You are, and see, this is what Ty Tucker should be doing when he goes before during jury selection. One of the things defense attorneys will do when they're in the jury selection is they will say, okay, so the burden is on the state, and there's a presumption, and a presumption of innocence lays with my client. So do you know what your verdict should be right now? If you had to vote right now, judge said vote right, what would your verdict be? Most people say, well, I don't know what it would be.
No, innocent.
It's innocent, right? It's not guilty.
Mm-hmm.
That's what the presumption of innocence is. And they should do that with every single jury, because that starts to set the tone of what it is. It's presumed, and that's what makes it different. And what Ty should be saying, do you know what your verdict should be? I'm innocent. And guess what? The best part about it is because I am, and you're going to learn that in this case. And be damned if the judge wants to step in and say, Mr. Tucker, you can't do that. Oh, you can't do that? You're going to, and if I was Tucker, I'd be saying, what? I'm an innocent man, judge. I'm fighting for my life.
Absolutely.
The state's trying to take my life, and I'm innocent, and I want to do it. They're trying to lock me up for the rest of my life in prison. And to hell with it. That's why an attorney couldn't do it. And the only reason why an attorney wouldn't do it is because they're afraid they're going to get censured by the state bar, and they're going to get their license suspended. Ty Tucker don't got a license, so he should be doing all of that.
Nobody had a license.
Right. Well, but I'd still be bound by the same concerns, when you go in there, so you can't defend the case that way. But but the point is, he's going in as pro se. So the most effective thing is don't pull Darrell Brooks and look like a complete lunatic. Go in there and look like an innocent man, and talk to them, and
back.
Correct, and bond with them, and try to get with that jury, and be confident. Not again where I believe everything went, where he lost probably some of the jurors, if the jurors that were on the fence post that maybe went back there and said they were going to be 8-4, because I believe the jury, my understanding is it was 6-6, then it went 8-4, and there was one juror on there that was just dead
adamant.
That was very adamant that Ty was innocent, and basically made it clear to everybody. But there were three more that were still with that person, and we were like, well, we're not adamant on it, but we're not convinced. And then that was why they said, well, the case ends. I don't think we're going to move it. But if Ty would have stood up there and said, I'm telling you to believe me. You don't have a choice but to believe me, because you got to believe me, because I'm innocent. This isn't a situation where this isn't like you're going to mom and dad and going like, hey, well, you don't have to believe me. You can believe them. But no, this is, you need to believe me, because the blood of an innocent man is going to be on your hands, each and every one of you. And that's the stuff you said. And then Judge Jones said Mansfield would have been jumping up his little big butt up.
Out there.
And he would have been, it's already out there. And then Judge Jones would have told him, you watch. But again, like I said, Ty was, let his emotions get the better of it, and he got thrown off his game, and he wasn't he wasn't necessarily, he was trying to, I think, bind the rules and at the same time that he was also trying to show, I think he thought, well, I'm going to show the jury that I'm following the rules. I'm following, but that's not really what you would expect in that situation. I mean, there are a lot, like, this is not a situation where Ty Tucker goes away and he's getting out in 10 years. Ty Tucker was sitting in that courtroom when he came in January, which I thought was wild. He's in this courtroom, he's defending himself, and like, he gets found guilty. He's going for life. It's life.
Yeah.
Sorry,
go on.
No.
Answer first,
No. Well, I was gonna say, I saw that comment there. I was just saying, you don't get to argue your case. No, but what you can do is you can tailor questions that can kind of start to push the theme of your case or what your argument's going to be. So I think Ty will be more aggressive now, because I think what he's seeing now is
they're not playing.
Well, yeah, and he's got nothing to lose now. He's locked up.
Yeah, absolutely.
And I think the fact he wasn't locked up was something that hung over his head, even though
maybe he can use that to his benefit to the jury as well.
Well, they're never going to know that, because he'll be in plain clothes, and he'll be allowed. Now, that's the interesting part. I don't know.
I mean, tell them why he got locked up and that he hasn't been able to prepare properly, or
no. He can try. Well, listen, he can do anything he wants, but what's going to happen is Judge Morgan's going to scream at him, Mr. Tucker, you quiet, get up here. Now, the question I don't know is listen, the logistics of this whole thing, because normally, you don't have an in custody defendant who just gets to walk all over the courtroom. There's security concerns on that. He could literally decide, you know what, I'm going to jump the thing, and I'm going out. I'm, getting the hell out of here. But so I don't know if he'll have the degree of movement he had in the last trial, where he's able to go up to the judge and do the sidebars. I mean, he has to, because he's his attorney. He's his own attorney, but he can't. He can't, because of the presumption of innocence. They cannot. The state nor the court can make it apparent to the jury that he's locked up, because that goes against the presumption of innocence. So they can't bring it up. It's just like why a lot of times they talk about, like, in a police statement or a mug. I mean, the Benefield case, remember, it was they had the issue of the mug shot, and they were like, in the state's like, well, you should know she was arrested, but it's very important that you don't do anything to show her in a way that makes her look like the police were there. There was a show of force, because that goes against the presumption of innocence. Yeah. And they can't do that. They have to let the evidence stand for itself, but they can't do anything to try to make her look like she's already considered guilty.
So is he staying at the Munroe County Detention Centre, and it's being tried in Key West, because they've requested it be back at Key West for that reason, isn't it?
Well, he's the detention center that he's in. That's the whole issue. There's Marathon and there's Key West, and Marathon is an hour and a half away, because I guess it's a kind of a big county. So he is in the Monroe County Detention Center, which is in Key West. Okay, so the issue at hand, right? So the reason why that's come up is, I guess, Judge Morgan is based out of Marathon. So the state raised the issue that said all of our witnesses, all of our people, and some of the witnesses are like homeless, and have transportation issues, like Roger Ruggett. The experts, all the logistics of it. It says for us to do a trial in Marathon means everybody has a commute every single day, including Mr. Tucker, who will now, again, one of the factors that definitely has to be taken into account is, normally a defendant. And again, believe it or not, it's if you want to know what it's like, go listen to the Charlie Adelson tapes. And he talks about what an arduous, difficult, energy draining process it is to go through the process of getting transferred to court. It's not easy. You're put in shackles,
Every
you're
day.
brought here, you're brought in every single day. It starts at like 4 a.m. So by the time he gets there at 9 a.m., he's been up like 5 hours. He's exhausted. He hasn't, you're eating a brown bag breakfast. I mean, my point is, you're going into court now to start an 8 to 10 hour process of arguing motions and doing all this stuff. You're already exhausted. So one of the things, and imagine him having to be transported every morning an hour and a half to Marathon. It would begin the process of saying, well, this could be an unfair situation for Ty in terms of making sure he's in tip-top shape to defend himself. So I think they wanted to alleviate any appeal issues. That's why the state was saying,
okay,
there's a litany of issues, but
they're dotting their I's and crossing their T's, aren't they?
So the only one that's going to be inconvenienced will be the Honorable Judge Morgan, who will either have to decide whether he's going to take up at one of the resorts in Key West for
at the state's expense,
at the state's expense, or drive an hour and a half to 2 hours every day down to Key West. And I think the judge says, well, from an expense perspective, put me up at a 5-star all inclusive down there, and we can call it even.
They will broadcast it, won't they? They will live stream it.
I don't know. I've talked. And again, a reason why I say this, I've talked to the clerk's office because I have tried to every single hearing I've called in. I keep calling in. And this last time I went all the way to they were trying to send me to Judge Morgan's judicial assistant because I was basically saying like, I'm a friend, I'm an observer, I want to observe, and I'm out of state. And Mr. Tucker told me, call in, and check it out and see. But what I'm told, I said, well, is the trial, can I at least get a link to the trial? And they said, the only way at this point, there are no requests at this time. Doesn't mean there won't be one.
Really?
But I mean, there's no request by any networks at this particular moment.
For a media feed?
For the trial. Now, they said a lot of times the week before is when it'll come in. But I don't know when. I'll have to go in the file and see if I could see if there was any requests put on the record in the first trial. But they said normally that comes in like a week or 10 days before. So we'll see. But we hope because otherwise it's going to be difficult to know what's going on. Now there is going to be a journalist on the ground in Key West. In the courtroom who's covering it, but we won't know what he sees until after he finishes his project. I mean, I would have the ability to maybe, tap him every day and say, tell me your thoughts. And he'll happily share because he's disturbed as well by the way they're trying to keep everything. But he's not down there right now. He'll be down there later this month. So it's a situation where, really, unfortunately, the state.
He's got no one, has he?
No, he doesn't. And the thing is it's not like it's convenient. If this was a convenient place that you could drive, if this was 2 hours from my house, I'd drive down there every day and do it. It wouldn't be a big deal. But, it's not exactly the most convenient or the least expensive place to travel. I mean, you go down to Key West, you have to stay in Key West, and you've got airplane tickets are not, at least going from the DC area airports down to Key West, are quite expensive. Because like you literally can't, and you can't get down there. Like a lot of them are, I guess you got to have a layover in between. So it's like, you leave literally the flights going down.
Don't
are
worry,
like
I've looked into it.
6 to 8 in the morning, and you don't get down there till either in the evening or whatever. So it's not like you could just quickly go, okay, I'm going to fly down and fly back. And it's, $700-800, to fly down there, at least from this area, because of the different connections and where you're going. Then you got the hotels, and you're talking about a resort town. So it's people go down there all the time for stuff. It's not like it's the most expensive spot in the world, and you don't have to stay at one of the 5-star resorts down there. But my point is, it's not convenient. It's not like you're going to get a group of people to say, let's drive down to Key West today. It's literally at the farthest south point of the United States on the East Coast. Yeah. So this is not convenient to get a group of people down there to say, let's go out in front of the courthouse and start protesting. Like what really
that's the
should
other
be
thing
needed.
I was going to mention. Like I sat down yesterday and decided, because there are so many similarities between Karen Reid's situation and Ty's situation, and
Mhm.
the difference in the amount of interest that Karen Reid has as comparison to Ty. And unfortunately, the only thing I could come up with is that Ty's not a babe.
Well, there's a second factor. There's a second factor too, and the second factor is why also the second factor is Ty's perception. This is a situation where Ty is perceived to have had a drug problem, and that he was around. So it's like people have a problem supporting that. It's like, oh, there's a band of people when you get into the Gregor case that I was talking about, and the mom. People are like they want to blame her because she had this substance abuse issue. And the reality of the situation is that really doesn't that doesn't matter. Like, we're looking at the case, the
No.
facts of the case and things,
Yes.
but people really get affected by that. So it affects the level of support, because I know I've interacted with people, obviously, in comments and videos I've done. And one of the sticking points that they have is it's really hard for them to be like, well, he was in this drug house and he was sitting around, he was doing drugs. So this is not the poster child for like, we want to support this guy, because, man, it's like, well, you should have been hanging out with this type of people. You shouldn't.
But at
You
the end of the
shouldn't have
day,
had.
he is no less deserving of
Correct.
a fair trial.
Right. And Christine, I'm sure, I know he does, and I would love to get people down there. Like I said, and the other issue is the timing of the trial is such.
This is
that,
why we're doing this.
Well, like for myself, I mean, I've got two factors going on. Number one, obviously, it's not convenient, but the second part
Baby on
is
the way.
well, not yeah. My wife is supposed to have a baby, but then she's having a C-section, so she's going to need assistance and help for that. That's like the key time. I can't leave her, so I'll watch from the house. I've already told her that week I'm not going to be out working or doing anything else. It's going to be watching and reporting on the case 24/7, doing daily trial watch, recounting it at night, working with everybody that wants to do it, and we're going to keep a good voice out there. That hopefully, I hope. What my hope is that places like Court TV, places like Law and Crime decide to pick up the case, and then they go in and they
need to bombard them.
Well, the bombarding will happen when they do what they always do, is they'll research the case to see what's been going on with it. They'll go to his Facebook page. So when you put a video up, link it to his Facebook page.
Yep. I've actually got a thing of all of his links, so I will put that up.
You should link your videos. You do a video of it, put it up on there. Not that it's going to like blow up it's not like it's going to blow up the views on the video, but what it's going to do is it puts it in front of, first of all, we know the district attorney's office is watching everything that's being done. So they're aware of stuff.
Oh, really?
Second, oh my gosh. Yeah. They were, when he would post stuff on there during the trial, they were talking about my channel, Mansfield, during the trial, because my channel had popped up and I was reporting and dealing with stuff. And he said Mansfield got so angry with the judge because he said, he started a new YouTube channel, and he was talking about my channel because Ty had put one of my broadcasts up, and Ty was in the chat, and Mansfield was talking about it in court. Yeah, they watch it, and then I go on and post it to, they have the MCSO and the MC, the sheriff's office down there. I'll put a link. You can I'll go drop a link on their page. They take it down, but I know they saw it because they took it down.
Yeah. Well, I've tagged every one of the major true crime YouTube creators to this video, and I'll continue to do so, just so that someone goes, and I'm trying to link it back to Karen Reid to get their interest, to show that the similarities, there is so wrongfully accused with charges and factual innocence, and
I think they're aware of the case. But I think, again, because they were a lot of them, I mean, if you go back and look, some of them covered it, mentioned it. There was the fellow that was out of, he's a Texas attorney, and he's licensed in Texas and Virginia. And Ty went on his show. I'm trying to remember the daggone name of the channel. But they're aware. Again, they don't care. What we really need right now, though, is what I'm shocked about.
Cover the trial at the end.
Right. They'll cover it if it comes on TV again. But what we really need is somebody like Vinnie Politan or Law and Crime or one of these shows to decide, or
Yes.
Dateline, or someone to take an interest. And at one
Share
point,
this
Ty,
video with everyone.
well, to
All of 'em.
me, what I don't understand is supposedly Ty had said Netflix had been involved in producing a special, and then because of the gag order, it never got out. But I felt like after the first trial, if there was a true special there, something like that needed to be released. Why? Because that's what generates social media interest. That's what's going to get people buzzing about it
I
and
didn't think they
interested.
could if there was a pending trial still.
Oh no, they can. I mean, because the trial already happened, the mistrial already happened. They can absolutely do that.
Okay.
It's just like Murdoch. They did his murder trial, or oops, I said the word. They did his unaliving trial. I'm not good at that, so.
No, me neither. Don't worry.
So sometimes I run
Doesn't worry me. I'm
afoul.
not monetized yet.
I run afoul of the monetization standards sometimes, and then you just got to go in and like clip it out or
Did
something.
you get reaccredited with YouTube?
I did, yes. I'm back up.
Awesome.
I had to
So you
fight.
can do-
I had to fight it.
Super chats.
Well, here's the deal. I mean, I
No.
applied, and then they denied me, and then I went in and I had to do an appeal. This time I had well researched what they needed. So I spent that fact. That's what inspired me. I had kind of not been streaming, and I did my return back. I was talking to somebody about the case for a podcast that they're doing. So I was here at the house on a call with them and doing stuff. And then on top of that, during that, I was trying to email audio and stuff to this individual, and I saw that my appeal had been turned down. And I was like, holy cow. So I stayed at the house. And then when I got done with doing my appeal video, which took me about 3.5 hours to send to YouTube, I was like, great, I'm sending it in. And then I said, you know what? Let's get inspired. I'm fired up now. I've been talking about Ty all day. I've been videoing all day. And that's when I decided to go live. I think it was episode 20, I think, of my live show. And I said, okay. So I came back and did that. And then that night I was checking comments and stuff. And all of a sudden I saw all the green back. And I said, oh my God, I won the appeal. So it only took like 3.5 hours for them to go in and review it. So they returned me back. I was really upset because I didn't understand why. I mean, I understood what happened before. I made a blunder in trying to do too much with the verticals, but I couldn't believe that they didn't. I mean, I took everything down. I bare bones.
Yeah.
Well, they didn't warn me or nothing. And I was like, you know what? I'm trying, because I did that. Now it kind of hurt me a little bit with the algorithm because I was just flowing really well. So by doing that, it kind of resets almost everything. But I did that. I thought, well, the stuff I have up, I know for a fact, like we're good. And pretty much I had eliminated everything that I knew was questionable that had gotten like hundreds of thousands of views that I knew was like, well, I shouldn't have been, because basically what happened was I was trying to promote my stream. So this is just a cautionary tale. You cannot, as I learned on the vertical, I thought, well, the verticals are cool because you make it's the short live stream. You make no money on it. You really don't. Like I had like almost close to 1 million views on one of my lives on that. And I made I think it was like $27. I mean, if you got 1 million views on an actual video, you'd be making
it directs traffic, doesn't it?
It directs traffic. And that's how I grew my subscriber count. When I was doing all of that, I had some streams that were generating 500,000 people, not at one time. It was like 900 to 1,000. In fact, I'm back on I'm doing it differently now because when I'm doing my daily trial streams, I'm running a dual stream to the vertical and to that. So it's the same stream. I'm not reusing content. It's new content coming onto the algorithm. But people people on there like to see that stuff because they're tired of watching the weird belly dancer that's like dancing and doing all their, so they're like, oh my God, a trial's on, and they're come in. Yeah. And what happens is, I mean, the first day I did the Benefield case on there, and I didn't even do I think it was day 5 or something. I got 700 subscribers in the 5 hours it was on. I mean, it just boom, and it shoots you right. It just starts building. Now, the thing you've got to be aware of is it doesn't necessarily bring you viewers to your long form content. These are people that are the swipers. So you've got to make sure you're going to understand that these people will probably watch your shorts. They might watch. They'll be looking for you in the live feed, but they may not come in, and they're not going to be the people that are going to sit there and watch you for watch a 3-hour live. They might not. They're not going to contribute to you.
Yeah.
That's not, but at the same point, what it will do is it will, again, those are good people for what I'm trying to do in my channel, because I want to be able to drop a short, because one of the things I do when I can sit in the box, which is what I call sitting in the box, which is down the corner of the screen. What I like to do, what I did with the Ty case and everything, is while I'm watching, I'm clipping, because I'm looking for moments I want to show and I want to highlight where I feel like a defense attorney's not doing what they're supposed to do, state attorney's not doing what they're supposed to do, judge acts out, and I'm constantly looking for those opportunities to clip it, throw it into a short. Or if I want to do a bigger version of it, I might even, highlight it on my live show and talk about it as something that we're going to rewatch. And that's key, because you're going to throw that in there and those people are going to see it. And that's why I'll throw a short up. I'm always getting at least 1,000 to sometimes 50,000, 100,000.
So you get more subscribers from your shorts than you do your longs.
That's
the issue I've got. My time watched hours are going through the roof. But
if you're going to build your channel right now, the algorithm, you will spend 5 years. And I know, because I know. Well, I know, because I built in another genre, which still exists, that I go out and do. You can see me. I go live over there too a couple times a week. I am over there, and that channel has like 2,000 subscribers, and I have had that channel since 2021 in 3 years. It's slower, but I don't do the short content. It's totally different formatted. Over here, I mean, I've had people come in my comment, did you buy subs? I'm like, hell no, I didn't buy subs. Why would I do that? No. Like, I'm not making enough money to make it worth it. Like, I'm not worried about that. I never expected to be at 30.
I want to know I did it on my own merits.
30-some thousand subscribers. What I did was I started doing shorts. I started clipping court cases and turning it into my own and putting my own commentary on it and putting stuff over on it.
And you put that back on YouTube, or do you put that elsewhere?
No, I put it back on YouTube. You want to be careful putting it elsewhere, because that can also be a way, like some people have gotten busted for reused content, because let's say you take that exact short and you put it on your TikTok exactly as it is on YouTube. YouTube will consider that reused content, because if it blows up over on TikTok and they see it, and then they're like, oh, the algorithm doesn't know whether it was on YouTube first or.
What about X?
Twitter. Well, what I do with X is I just put the links to my YouTube videos for X. Now, and I'll directly live stream to X, but that's what I do over on X, because that way, like, it's just directing traffic back to your YouTube. Now, X has a different thing. They want you to pay to get your monetization, and they're push you. I mean, they have a totally different model that I haven't dug too deep into. No. And then you have Rumble. Rumble is a strange little platform. It's a strange little platform, because you're monetized from day one. But my God, I mean, I think I've had some videos that have done, never done more than maybe a few hundred to 1,000 views over there, which is the same lives I've been putting up on YouTube, which I'll multi-stream right to all of them, all three of them. And it ends up bringing, like, I think I've made $6 in the entire time I've been on Rumble. Yeah. So, and there's a lot of complaints, because Rumble doesn't pay you out monthly. They make you get to a certain threshold, and then some people have had problems getting paid. So Rumble's kind of a backup deal. I put I put stuff over there, but then there's also
you get shut down on YouTube.
Well, and then there's the issue right now. I haven't even been able to start a live on Rumble, because Rumble also has, like, they don't have the data servers that YouTube has. So uploading a video takes hours, even if you have a fantastic internet connection. So a lot of headaches that they're working out over there, but I'm just happy that YouTube's got me back. But yes, what I do.
So you can get super stickers and
I can get all of that now. Yep. Stickers, super chats, all that.
So
yep.
Do you hear that, everyone? Steve can get super chats and super stickers again now.
Yes, memberships are back up. So I had everything over at Ko-fi.com. So now I'm probably going to.
Hang on 1 second.
Going to transition.
Oh, look at that.
Ah, there it is.
And the actual links, they're linked to that. Like, I've attached the link to the thing. If that makes sense.
Well, like I said, I'm still keeping all of those areas up because you never know. You know, I'm not going to take them down, but I am back up on the official front because what I found out is it is very like now I'm happy I don't have to put the links in every video because boy, that just takes time. And then you get over there. And now the nice part about those is as a creator, why those should be options is if you do have someone that wants to make sure you're getting more of the money and not YouTube because YouTube takes 45% of all your super chats.
You can get these third party.
They take 45% of all your income. So your CPM and everything. Yeah. It's in the CPM in this genre is a lot less than some other ones. In other words, the payout. There you go. Yeah.
I forget to do this.
but what I would do, Jody, is definitely like, you know, when you're watching a court case, you know, mark some time frames. That's what I do. And then spend a few hours. Now, I haven't been as vigilant because my wife pretty much, you know,
you got a full plate.
Well, yeah, she gets, you know, it takes time. You know, when I first started everything at the beginning of this thing, I'd be up, you know, I had quite a schedule. Then I broke that schedule when YouTube pissed me off. And I said, well, I'm going to focus on other areas because I got to make money, you know, to a degree. I'm not trying to make a lot of money, but you got to keep the lights on, you know, because as you and I were discussing the cost of the streaming services and all that stuff. And, you know, at least YouTube's paying for all that now. So that's why I can justify that now. But before, when I was off that, I you know, you're paying over $100 a month for the streaming services and stuff like that. And
YouTube Premium and
YouTube Premium. Oh yeah, I probably got. I've got better internet. I mean, I probably, if you add it all together, it's about $200 some overhead that you've got to do all of this, and then keeping your equipment upgraded and making sure you've got the different things. But that's my goal with now. What kind of stopped is like now I can go back and say, okay, we can keep improving the broadcast and getting better stuff. And also my goal at some point, I had hoped I was going to have a stream of ad generated revenue that would be coming in. That's what makes it possible to go down to a trial at some point and get on the ground. You know, if you've got streams of income, not talking from but we're talking just your YouTube, and you can put that out and you've got viewership coming in and you're getting, you know, the viewership that's generating money for you. That's what would allow you to go down there and say, hey, we're going to go do this. Maybe even do help start helping to generate the buzz and put forth stuff. But it's, you know, it's difficult to do that stuff. If you know, so that's why I'm very happy, but it just came back, everything just came back on the 11th of July. So I'd love to run there to get there. But now the plan is, like my wife said, slow down and just do it. Don't take chances and just, you know, do it steady and keep going. It's like yesterday, you know, but the other thing you can do, Jody, too, I don't know if you do this, is when you're doing your daily court cases, okay, in YouTube Studio, when you're sitting there, you should clip out, like when you have a witness that comes on, not necessarily the whole testimony, but say some significant portion. You notice Law and Crime does this. You have the right, YouTube provides it to you, to clip that out for your audience, and you can put a title on it. The description for that video will end up, everything you have in your description will end up, and it will generate a video instantly. And if you're doing that throughout the day, you're creating videos. You know, some people will look at it's additional content. That's completely okay for you to use, because they want you, when you have a 5-hour live stream, you know, you're able to highlight that. And there was some cases I've done that if you go back when I was doing the Crumley case, I was clipping out different witnesses. You see where
yes, I saw that. Yes, yep.
And that's content. And then some witnesses, I got 20,000 views on it. Like yesterday.
Ken McCabe.
Well,
off the top of my head.
Well, right, exactly. But that's where, when you have your monetization intact, that's where sitting in the box. Now, I will tell you, if you're trying to really focus on the trial, you don't want to get too involved in creating all that content, because you're kind of start missing things, because while you're clipping it while the next witness is testifying.
I just make a timestamp mark and then go back later.
Well, it's just easier to do that though while it's happening, because you can throw that in, and now that's going to throw more people into your live.
Yep.
So that's why I'm pointing that out,
Okay.
because it's going to get you in the algorithm. I have watched,
Yep.
and this is, I know we're getting into stuff that's like probably the viewership, but one of the ways you can get into the algo is you start throwing those videos in. All of a sudden, YouTube will start promoting your live, because people will start clicking in. Because remember, when they click into the video on their phone, there's going to be a little, there's a little red dot that says you're live. So people will go and click that and get into your live. They're coming and start checking it. The more people that start clicking into your live, now the algorithm says, oh, there's something interesting going on here. All of a sudden, you're going to see the impressions go up, because that's really the key. That's what we're all fighting for, is to get your impressions up. And then if you've got a decent thumbnail and you've got a good video premise, people will click.
I'm good at the thumbnails.
And then people will click in, and then you're going to get views. And then in your case, you're trying to build subscribers, and you really want to build your subscriber base off the people that are willing to click your live. So, you know, but at the same point, you want to get to a point where you can take advantage of when people click into your live, and maybe they click in and they watch it for 5 minutes. Once you really get into the monetization side, it really doesn't matter how long they watch. It just matters that they watch and they get the ad played, and then they go in. And then with what we're doing, there is a big opportunity there to really get good ad revenue, because you can set up the mid rolls to come in and play that ad. You know, you don't want to disrupt people's viewing pleasure, but
AJ and I do a lot of dual streams together of the trials, and she's got this with her ads. Every time there's like a sidebar, she goes boop and presses the ad.
And presses the ad button. Because you can
and
do it.
Someone comments, she goes, "I'm giving you another one."
Because you can manually do that, or you can let YouTube do it, or you can even boop, So it's but that's what you want to do to try to build the you know, to generate content and get out there, because remember, like content like this, it's timeless.
Got a shit ton of content. I just need to get.
It's timeless, but it's also time, isn't it? Which is
that's my baby. That's my baby.
Oh, is it really? Oh,
yes.
Welcome. But it's a matter of, like you were talking about, I'll write down the timestamps. The problem with that is you won't believe what you're going to have to do then. And you won't believe how many times I've done that. And then you don't make it back in, and then you're in the next live the next day. Because when you get done, you can't clip out your live until it's finished processing. If you have an 8-hour live, that could take 10 hours before they let you have access to your timeline. Okay. By the time you do that, you're into the next day, and then you're like, whatever, I'm not going to have time to go in. And then, you know, you've got to go in then and actually recreate descriptions and all that stuff. The quickness of being able to clip and highlight is what you can do. Is if you don't want to have it all flood on your channel, or you want to be able to do thumbnails, you can just private all of those. So you can do your clips, private them out, and then go back afterwards, and you've got the clips. All you've got to do, all you've got to do then is you can decide how you want to drop the content. You'll notice Law and Crime will drop content about, you know, it'll be like once every hour in the evening, you'll start seeing clips from the previous day's trial come up. No. And the way they're doing that is they're highlighting, clipping, privating it, and then turning around, thumbnailing it out. They're letting a thumbnail generate. Well, because remember, YouTube will generate a thumbnail, so you can download that, and then you can overlay that over and put, you know, Jen McCabe accused of being a liar. And then you can create that thumbnail really quickly, put that on top, and then say, all right, I'm going to schedule this to drop at 6:00 as a premiere, or you could just drop it at 6. And then you could have the next witness, you know, so-and-so cross-examined, outburst in the courtroom. And you can sit there when you get done with the trial and do your like afterward and have it. So there's a video dropping at 6, at 7, at 8. Maybe you're going to do your live show at 9. Now you've got these videos you can incorporate it and
lined up the top, ready to go.
And they're all lined up, and then you boom, boom, boom. And that's kind of what you got to do in this instance, because if you got to sit there and go, okay, well, let me try to go in here and clip this out and put it, you're never going to be able, it's going to take so long that you're going to be like, oh man. And then by that time you've lost your slot to be able to go out and talk to anybody, or you're doing like I'm doing sometimes where I'm going live at 12:30 and 11 or 1 o'clock in the morning and everyone is asleep.
Oh, I don't know what you're talking about, Steve.
Well,
You're going live. It starts at 11 p.m. here.
Well, no, but
It
you're
goes
right, but you're there when your audience that that can watch you is up. I'm going live when everybody's actually asleep, and then they catch it in the morning time, which is again just part of just the craziness of my schedule because I've got so many things going on. But eventually, I want to get to that point, which I was at when things were prior to the debacle, where YouTube took my monetization, to where you can literally, when a trial comes up, it's like trial time. You're in there, you're clipping, you're doing this, you're doing that. Take a break. Now you're taking a break, you're eating dinner, and your channel's still churning out content. And then you go do your 10 o'clock live, talk about the trial of the day, go over the clips that you have, and then, you know, boom, you have content still going throughout the night, you know, or till midnight. You have your videos, and you just produced 6 or 7 videos. Some might get 40 views, some might get 100 views, and then you have one that gets 10,000 views, and now you just made money on that. Well, it's like, well, to give you an example, yesterday I sat for the first time in a very long time. I sat for a live hearing. It was the Gregor case, one close to my heart. I sat and I started clipping. And if you look, I've got a video on there right now that's close to 10,000 views. I think it's got it was like 7,700. And it was just it was an 8-minute clip of the father who decided to have an outburst in court and jump up and demand to be able to speak of the defendant. And of course, that is one that just got people clicking. And again, the normal YouTube algorithm, I went on vidIQ and looked at that video. It's like in the yellow, you know, it's like but it's true crime is different because people are clicking on that because they feel passionately about the family and what they want to say. And now that one's got some, it's not going to be like some massive earner, but you know, it could eventually get 20,000 views on there. You know, it could stop at 9 or 10, but right now it's got a 27.5% impression rate. So YouTube is keeping on pushing. Yes. And that's off of a YouTube generated thumbnail. So the point is you do that. And I clipped several videos from that, some of which I thought were going to be popular, and they haven't really gotten very popular. And the rest, but that one jumped, and that's the whole goal. And the other ones might jump. YouTube might decide to go jump that one tomorrow, you know, so people might take an interest in it, or it might sit and you might get 300 views over the course of it.
But then you get both, the beauty of both.
Well, right. And then you're getting, and again, remember, it's a numbers game it's a volume game. Let's say you got an average of
your bread and butter, and then you get your,
well, if you do 10 videos, let's say you did 10 videos a day and you did an average of 250, that's still 2,500. I mean, it's not a lot of money, but you know, there's a little bit of money each day that you're getting. And then you get a couple videos that pop, and then you maybe do a presentation and you do some lives that have meaning and people are in there. And I mean, there it is, but it's a unique play. This is a unique area for if you're a trial watcher, true crimer, because the trials provide just continuous content. It's just getting a good strategy to take what you're doing and make sure you're adding the commentary that's needed and bringing in what you need. It's part of your live. It's affiliated to you, and taking that, personalizing and clipping. It's like right now I've got a trial. It's the trial out of Wisconsin. In fact, as we speak right now, day 2 is airing. The premise of that is I went in. It's the tattoo trial.
The punch.
Yeah, the punch trial. So I went in because the court TV. I think
today.
Well, no, I went in because of course I subscribed to the different news media, but the one place out of Detroit literally has like clips, like they would do their trial coverage in bunches or whatever. So it's like you got to watch this video and then this video. So what I do in that instance is I edit it together and put it together and clean it up and clean up the audio, and that again is making valid changes to it. Put my own little deal on it for it to be watched. Now I have that, and then if I want to sit in the box, which I didn't sit in the box for that trial, but I could technically sit in the box and give commentary for it or speed it up, and it runs through. So, that one's running. And sometimes there's, the first one ran last night. I think it was like, it's gotten, I don't think it's even got 100 views because my other video was taken off. But again, it sits there and people will have an interest in it. You can put it in a playlist. You can do different things. I can add commentary to it. I can cover it, and with that, you just got to be able to capture the trial itself and then be able to edit it together and put your own likeness on it. It's in the public domain and put it up. So, and I have a couple for other ventures that I have a couple of cell phones that I use for, capturing content and stuff.
Yep, fair enough. Whatever.
Which I'm like, hey, why not?
Guess what I've got?
What's that?
I have a
document. Oh yeah, we went way off. We went way off the reservation.
What's this? This has got something to do with a public defender.
Oh, the notice of regional counsel. Yes.
Is this the first one? Or the second one?
No, this is the second one. I believe.
One is
see if can you scroll down real quick? I want to see what the attorney's name is. If it's Zenobi, yeah, okay, that's the second one. Yeah.
Second one. Okay.
Yes.
So we want the. So that one?
Yeah. So this is a motion. Well, this is the motion to withdraw by the. Well, scroll down real quick. I think this is Zenobi again. Yeah.
Yeah.
That's Zenobi.
No, I've got another one. There's another one.
Right.
No, that's show cause. No, that's not guilty. No. Where is it? Motion in limine.
Mm-hmm.
There we go.
Okay. So
this is
this
the first one.
right. So this one, right. This is the motion for where the public defender's office is saying they had a conflict. In the conflict is they represented John Travis Johnson. So they cannot represent a co-defendant. So that they got conflicted out.
This is the judge initiated public defender. Is that right?
Well, we don't know exactly. This is the court. I don't know how it all went down, but he filed the indigency motion, and I have a feeling. I think they didn't. They
2 days after your stream.
Well. My thought is that what they did here was because they could have waited till he appeared in court or tried to get in, or had a hearing on it and said, "Do you want us to appoint counsel?" But and clarified it. But what I think, like I said, I think there was a desire here, a strategy here to appoint him counsel to then have him effectively waive counsel on record, which is what you see happening here. So all of this is happening because they didn't have the court date until the 1st. And then he comes in and the public defender just naturally, they get appointed, they get conflict. They realize there's a conflict. Zenobi, who was actually in there, if you go back previously, he was already there once and he conflicted himself out because he was representing Roy Wilson. Regional, he's out. Yep. And that one is the same issue. They come in, he represented.
Sorry, that one. Yeah.
Yep.
So he withdrew himself.
He withdrew himself because the office, his office, the regional counsel, office of regional counsel represented Roy Wilson. And Roy Wilson is a co-defendant. So they're gone. So then it came down to where, again, they had it ready to go because Ty got counsel and had counsel at the hearing on the 1st. And that was where Ty told the court, and I'm sure Judge Morgan walked him through the waiver and said, hey, I don't want counsel. I was only, again, as was clarified in here by, I can't remember her name in here, but it's escaping me. But she was clarifying in here that the point of the civil indigency was this. I don't know if you recall, but I raised this issue as well. But Christine Fortunato was talking about that Ty didn't even have pencils or pens, or notepads. Well, you don't automatically get that as a pro se defendant because you're supposed to provide for yourself, and that's why I said there was a real conflict here because Ty had the appearance of having money through his ex-wife, who now ex-wife, who now wasn't providing him with financial assistance. And as a result, he wasn't, well, it was literally allowing the state to say, you're not going to have access to any type of financial resources, which is illegal. I mean, it really looks bad. Like I said, I can't help but believe I went live on that, made it a huge part of the live, and then attached it in with all those places. See, I attached it in. So that's the only reason why. And I put it on a Facebook page. So I know they saw it because they took it down, or at least they saw there was a live up there. I have to think that they're probably thinking, let's see what these people are saying. Or maybe somebody talked to Ty. And on that one, remember, Christine was on there, and I had her on. She called in, and she was talking about what Ty was saying, and was saying how terrible it was. And then we were going through. If you look at the motions that Ty filed, he was talking about in the motion that Ty put into the record. So most importantly, too, Ty had put that into his motion to dismiss, his emergency motion to dismiss, saying,
which is what I thought they were going to hear yesterday.
Well, the reason why I thought it was suspicious is they conveniently forgot to scan the parts where Ty talked about what was happening in court, where he was saying that the judge inexplicably was telling him, you must write down your motion. And Ty was saying, but they're not providing me with anything to write with because I don't have any money on my commissary account and I can't buy it. So the part of what he's doing here, or what he was trying to accomplish, was to be declared indigent. And now the state will provide him with all resources, including computer, to view his stuff.
But that comes with accepting the attorney, yes?
No, it doesn't have to. That's the point of what I'm trying to make. What he was doing is trying to get his expenses taken care of, so he can now get an expert witness. He was needing to get declared indigent so that he could now have an expert witness review the DNA if he wanted to. In theory, so he can have
attorney is only part of that.
I mean, in theory, if we weren't rushing to the case here, I mean, he could ask for a private investigator to be able to come in and assist him since he's locked up in the jail, to go out at the expense of a certain rate per hour, to go out and interview witnesses, go out and do things for him. Because I mean, every good defense attorney has a private investigator that's working, that should be out there talking to witnesses, compiling evidence, finding out stuff, going out, taking pictures, going out and doing the stuff like you were putting up when you said you're relying on Google. The private investigators there looking at every spot, taking pictures and saying, yeah, there's camera here. They're showing up at CVS and saying, was anybody here from 7 years ago that I could talk to? Do you know if Danielle Malone came in? Do you think you could testify? And they could come in. I mean, that was, my dad had like 3 private investigators that worked for him that came to his funeral. That were, people that he relied upon and that were just absolutely key to him being successful, because you need them out there asking those questions. But Ty can now ask for that, and at a reasonable rate and a reasonable amount per hour, they could go out and do work on his case. He could essentially, he could file the motion and ask for a paralegal. Say, I need a paralegal to come in.
Does he know all that though? Does that come with like a brochure of indigent? I can't say the word.
Well, I think the question would be then or legal assistant, or however you want. I think the question at hand would be, does he know how to file the requests? And the judge could decline some of this stuff. He's got to make a justification for it. But at this point, though, with it being a month outside of trial, there's not much. It's unlikely that some of these things will be done because, Ty, this judge wants to try Ty immediately as soon as possible. And of course, they've got these motions that are outstanding. I'd love to know what happened with them, to see what the judge did. But I got a feeling, listen, the judge is going to deny as many as he can. And some of these facts that Ty thinks are relevant, and they are, but they also can be thrown back to as a matter for the jury to decide. And that's how the judge is going to look at it. For instance, the Cosme video, the jury gets to decide what they see or don't see in that. The judge isn't going to keep the Cosme video out because they say, well, there isn't any proof.
You see a boat canopy.
It's corroboration of John Travis Johnson's testimony, because it's going to show that John Travis Johnson can say, that's Ty and that's Rory. And while we question the credibility of John Travis Johnson, that is a matter for the jury. Now, and same with the idea that he says, well, they're suborning perjury. That is a question for the jury. Yes, there is a conflicted statement, but it's not the first time that somebody comes into court and says, I'm innocent. You know, it would
But a
be, you know,
conflicted statement is doubt.
well, it's right. It can be used for that. But see, Ty is caught up in the idea that he thinks it's proof of a crime. And he thinks, well, that's proof that he's lying, and they know he's lying. And they very well might know he's lying, but there's a difference between, all right, we think he's lying, and proof beyond a reasonable doubt that you're going to go say they're suborning perjury. If they could have an email where Mansfield's saying, we know Travis Johnson's full of shit, but we're going to offer him a deal anyways. Or, you know, like, for instance, in one of the things that they had, they were, Colleen Dunn was feeding Matt Pitcher a script, which will come out, and that's included in Matt Pitcher's deposition. Where they were giving scripts out, and that's significant, right? That would show that why are you giving a script out to now. Giving it to Matt Pitcher, you can explain that away by saying these are just highlighted points I want him to testify to. But a witness like John Travis Johnson, who you say we know we need him to help our case. So here you go, John. These are the 5 points that would get to go before the jury, but they don't have something like that. What they have is a suppression motion that was filed and then withdrawn, and then John Travis Johnson now says, I'm going back and saying that the suppression motion wasn't what I said in that wasn't true. What I'm now going back and saying what I told Phelps. The jury has a right to know that. That is absolutely true. But it's not going to be a basis like Ty thinks it is, where you go, well, I'm going to ask for it to be dismissed. No judge is going to say I'm taking that out from the jury. Now they might dismiss, and that's part of why Ty had conflict with the attorneys that he's had, because Ty felt like it should have been dismissed. Well, no, it gets to go before a jury. You get to go make your argument before a jury. And if all the state has is John Travis Johnson and you've got impeachment evidence, then and they choose to put that case up, John Travis Johnson's testimony is the evidence. So the state is going to ask him questions. If you can prove they already know the answer to those questions and they've attempted to feed those answers to him, you know, and said, you're going to say this. Now then that's coercion. But guess what? It's not, and we know they're coercing him because they built it in, they baked it into the plea deal. But that is all things that can be presented to the jury, and the jury should take into account. And then you want to have a lawyer who argues how the judge gives instructions on how to interpret that testimony and how to evaluate the credibility. That's why you want an attorney up there saying, this is how you do it. This is what you look at it. So you basically say, Travis Johnson is gone. What else do you have? You have nothing. Like, there's nothing there. You take Travis Johnson, but that's why Ty said, I'm not doing some slick presentation. You got to a degree, because what you needed to have is a board up that says, what do they got? They got Travis Johnson. What do we have? Here's the judge's instruction on how to interpret that, on how to interpret it. You can disregard part of it or a whole. I'm asking you to disregard the whole thing, because these are all the issues that we have. You can't trust them. And like my dad,
he's got to write the jury instructions as well, doesn't he?
Yeah, oh yeah. But, and one of the things that he needed to say, or my dad always, I remember when he was in the first trial, he used to pass this on to Ty, and I did. And Ty said, I'm not saying something, I'm not trying to be slick. I said, well, all right, fine. But one of the things that my dad used to say was, when you had a case that was built on one man's word versus yours, the way you present that to a jury is you say, listen, this is how you evaluate this witness's testimony. The state of Florida is asking you to risk, and this is how Ty should determine, is asking you to risk my life on the word of John Travis Johnson. So here's what I'd ask you to do. Before you do that, I want you to go back and I want you to think a family member of yours, a child, a brother, a sister, and the only word you have is John Travis Johnson's to rely on, and you have to make a life or death decision on that person. And and the only person you can rely on, if you hesitate, if you vacillate, that's doubt, that's doubt, and you must find me not guilty. If you don't trust, if you must trust John Travis Johnson's testimony alone.
100%.
100%. And you must make important life decisions with it. If you wouldn't do that, don't do it to me. Don't put my life, don't risk my life on the word of a man that you wouldn't even trust. But if you will, then, but I don't believe based on the following. He lied here. He was fed this. He had filed. He was claiming at one point that he was being coerced. Then he changed his story and he took a plea deal. He had conflicts. We have we have, and you can get into all of the, again, if he was able to get tied up, all of the doubts surrounding his testimony.
Yep.
And then it flows from there. And that's how it needs to be termed to the jury. When the jury gets back to that room, they're like, oh my God, okay, so we take away John Travis Johnson. I don't believe him. Or maybe I think he might be true, but I don't know. I can't trust him. So I can't trust John Travis Johnson. What do we got? DNA is inconclusive. What do you do with inconclusive? Presumption of innocence says anything short of it's my DNA, you presume me innocent. You presume an explanation of innocence. So DNA, you presume it's an innocent explanation. You, what else do you have? I mean, there's nothing else. You got Roger Rugged. There's nothing else. That's what I'm saying. That's what's so frustrating. You got nothing else.
Yeah.
What else do you have? What else are they presenting? They had, the lady that came on the scene, and she just basically presented what it was. And then you put Paula Belmont on, right? Well, again, like I said, he put Paula Belmont on, and suddenly they use that as evidence in their own case. Now, if they're going to try to present that in their case in chief this time, sounds like they're going to, but that was stupid. So at that point, you just leave her out. You don't need her.
Yeah.
The state has nothing. If the state's choosing to not, and then in fact, you can make the argument to say, what case have you ever heard of, ladies and gentlemen? They didn't call Todd O'Quinn. They didn't call Paul.
They didn't call the lead investigator.
They didn't call any of these people. And then even if the state objects and says you can't say that, you just get it out there and you say, how do you convict me of anything? And I'll tell you what, I testified in this case, but again, he might stay off the stand because he's technically testifying every time he speaks. And he says, I'm telling you,
he'll take the stand again in the second trial?
It just depends. I think it'll be on the fly. I think, I think that, I think it opens up stuff. It opens up more rabbit holes for the state to jump down, because remember, it was inside his testimony that they were able to question him about the whole issue of the knife, but they limited his ability. Now, what he needs to say is I found out about it. And if the state is challenging that you couldn't see that's where an attorney needed to be present, because see, when they questioned him and said, did you tell Paula Belmont that? He says, well, I did tell Paula Belmont that. And then on redirect, he needed to say, I'm going to explain where I found out that information from. But the judge blocked him. But he needed an attorney there to say, well, I'm going to, if the state wants to say that that's not true, then we can, then he can be recross-examined on it and say, that's not true that the police said that. But then the police statement should come in. I mean, it's really a hairy situation that I'm not even myself completely sure all the steps that would go into all that. But the bottom line is, he needs to, he needs to have an attorney present for stuff like that, or at least an advisor. But again, like I said, he's not even going to get that. And this is why I haven't seen him raise the motion for a hybrid defense again. He needs to refile that because his circumstances have changed. One of the reasons why, if you get back and look at that early motion when Judge Jones denied it, one of the reasons the motion for hybrid defense, this is way back in September of 2023. One of the reasons he denied it was because he said that he didn't need to have an attorney in the courtroom because he could have access to his attorney via cell phone. He does not have a cell phone this time. So unless he could have his advisor, but because he wasn't even going to allow the advisor to be in the courtroom, right? It wasn't even going to be allowed to counsel. So now he can come back and readdress it and say, well, I don't have access. First of all, I don't have the money. I don't even have the money to hire an advisor right now, but I need an advisor, right? I mean, he needs to put a whole new motion together for that, just to readdress it and say, these are the circumstances that have changed. I don't have access to a cell phone. I don't have access now to the funds to hire that advisor. I need someone to be hired, and and if the court wants to provide me access to this individual, what are you going to do? Do it on the recorded jail lines? I mean, how are they supposed to meet? He was going to that advisor's office every day and getting advice on how to handle things. And that individual was in the courtroom at times, or was available to him. He would leave the courtroom or go out and talk to him. So I think it's, they've got to address that, because it's when they're getting into things like that, they've got to make sure he's protected, or at least someone's got to make sure that the judge has to be fair enough to say, Mr. Tucker, this is what you need to do, and this is how this works, and here we go. But I don't trust this judge to do that.
No. So let me get this right. He got offered the first public defender, who got then it was conflict of interest, so they withdrew.
Correct.
And now they've given him the second public defender, who then filed the writ of particulars and all this stuff for what is it? Discovery.
Well, let me address what happened there. What that is literally what occurred is something that they literally take the name of the defendant and put it in us, and they just type it in. That is something that's been filed. It's funny they even filed it at this point, because the case has already been tried once, but they file that on every case that they get appointed to. So that is just something that was probably attached to their notice of appearance, or it's just part of their notice of appearance language, and they just file it. So literally that was filed as what we would call just a pro forma motion, just something that they just had on their computer. They printed out, they figured out we just got appointed to a case, and it's like a clerk in the office just hits a button and e-filed it
and generates it. So what happened to the second one then?
Well, the second one, as I said, there was a conflict because the Office of Regional Counsel represented Rory Wilson. So as a result, they got conflicted out, and then they got private counsel. They had to appoint a private counsel from the private appointment list.
What happened to that one?
Ty fired him.
Right. Okay. So
when he got to court on the
offered 3 by the state, 2 conflicts of interest, and Ty said no to the.
And when he got to court, he basically told Judge Morgan, "I don't want a lawyer. I want," and again, we don't know what was said, because according to Flash Fan 85, I don't know how they know their information, but perhaps there's something that was in the record, or maybe they're talking to him or something. But apparently Morgan is not giving him standby counsel. He had standby counsel before. In other words, they just were not able to be at the desk. So apparently at this point, the whole point is they're having him completely waive any counsel, any access to counsel, and he's doing it on his own. And again, this makes it very easy. Again, you have to understand something. My dad used to say this, right? When you go to court without an attorney, a judge can do just about anything they want.
Mm-hmm.
They will not follow the law. It's only the presence of an attorney is the only thing that makes them pause. And I do understand Ty had counsel before that was outside of the Key West area. He should have brought in outside of the Key West area counsel that was from Florida. And they would have been, there it is. Yeah. Delray Beach. There it is. Marla Levenstein. I don't know who Marla Levenstein is. I don't know if she was very good or not. But he had,
does that mean?
What's that?
What does that mean? What does that, the plea of not guilty and waiver of arraignment and demand for discovery? He's waived that right.
Well, what it is basically they don't need a formal arraignment scheduled. So again, what that is something that she probably files in every case that she appears in. That's her standard notice of appearance. So she's essentially just making it clear that he's basically, what it is there are time frames. When one of the things you have to understand about criminal cases and stuff is there are time frames that are attached to when you can make a request for discovery, and you waive certain things when you don't meet those time frames. One of the biggest things that can happen especially in misdemeanor cases where you are not necessarily entitled to a jury trial unless you demand it. So one of the things that happens is if you don't demand a jury trial, say within 10 days, it's essentially looked at as a waiver, and that'll be addressed at your initial appearance, which isn't considered an arraignment. It's just initial appearance where they say you're charged with this. This is it. Decide whether you want to hire counsel or get appointed counsel. So the first thing appointed counsel or hired counsel is going to do is just have a document like that ready to go, pre-printed, where it addresses everything that needs to be addressed. We're pleading not guilty. If you don't have to request a jury trial, that demand's out there, and they're going to demand discovery. Now they've met every initial time frame that they need to make sure they're going to get everything they need to. If you don't make a discovery demand, you would waive your right to get some of it, get it. If you don't, in the cases where you have to demand a jury trial, if you don't demand a jury trial, you're going before a judge. A lot of people think, well, we'll go before a judge. A lot of times you don't want to do that because a judge, you want 12 people to have to come in and evaluate your case. A judge, a lot of times, isn't necessarily your friend. And in Ty's case, Judge Morgan now is creating the situation, where he's not going to have any lifeline. He's going to be in that courtroom, and he's going to be screaming and hollering. The only thing that will now be up in hands is whether or not they actually let cameras in, which I think they probably will if it's requested. But will they let cameras in the courtroom? Because they really need to be there. Flashbang was saying they're fighting over standby counsel. Ty had standby counsel. It was just the issue was standby counsel was not allowed to be in the courtroom. Now, I guess they're not going. Because now it's an issue of appointing that. I guess Morgan's holding. I'm not going to appoint someone on the state's dollar to be your standby counsel. You can either take a appointed counsel who handles your case, or that, because
him firing that attorney has basically impacted his ability to have a standby counsel.
Right, because I guess the judge is not going to let it.
Yep.
Well, Ty is already trying to appeal. In fact, that's part of what he filed he filed a request for transcripts. He's trying to appeal. He's trying to appeal some rulings. We don't know what they are because he wasn't specific, but he was requesting for the hearings for the first 3 hearings all the way up to the 28th of June. And he was saying he was going to be appealing something to the Third Circuit Court of Appeals.
They've restricted everything. There's nothing. None of the hearings are being broadcast.
Well, that's the problem. This is going on in darkness, and then
they're
the only
covering
thing,
shit.
Well, and then the only thing we have is the ability. And one question I heard earlier was, have I been able to contact? I have not. I was hoping, Jody, maybe you can help me finalize to get an account set up, but I can't figure out how. I can't figure out how to get any
accounts. I've got it all set up, but because I'm international.
Mm-hmm.
There's not enough space for me to put the international dialing code in with my mobile phone. So I can't get the verification code to verify the account.
Oh.
So they won't verify my account. So I've tried to put money in. I've tried to make calls.
I can't fund it. It won't, like when I go through, it will not allow me to get to where it gets to the funding. It errors me out, and I don't know what.
Yeah, me too. Wrong. You've got to verify your number.
Oh, is that it? Okay.
That getting out site, you've got to actually verify your number, and they send you an SMS to the number.
Okay.
And then you click get back to them, and it verifies them, and you've got to then, I think they actually wanted.
Yeah, Christine, hold on a second. Christine just asked, yes, if you can do that, Christine, that would be fantastic. Yes. And then you can call me, or we can give you a link or something. I mean, however you want to do it. Oh, Jody can send you a link.
I can bring her into the.
Yeah, definitely. That would be fantastic. We'd love to talk to him.
Yeah.
I'd love to have a conversation with him.
It was Christine who gave me all the information on how to get to him as well. So
and get him to give us an update on what happened in the hearing. I mean, that would be fantastic.
And
because right now there's
your money if you need it, Christine.
There's no gag order in right now, so we can absolutely broadcast it without any problems.
Oh, really?
Yeah, the gag order is not going to be. It's requested, but my understanding is it was not dealt with, and it will be dealt with on the 12th. But
I think as part of the the rules though of accepting the getting out account. I don't think you're allowed to broadcast live video footage.
No, but we can have the
video calls.
well, we can have the
She can record it on her phone.
well, we can have the audio is what I'm saying.
Yes, yep.
No, that's what I'm saying. Yeah, the audio
You
is
can
what
be on the phone to him and we can listen.
we can't put you're right. We can't put I know we can't put the live footage up, but the audio can come up with his permission. They can't limit that. They're recording the audio anyways there, but yeah, we just can't put the likeness up because they just don't want although she could record.
She could just have speakerphone on and we can listen.
That's what I'm saying. And then she can have us. Yeah, we can have a conversation. That's what I was planning to do was have a speakerphone up and be like, not show tie, but just have the speakerphone up. Why? Yeah, it'd be like having somebody in our living room right now. I mean, why can't we? She could ask him questions for us, and we can listen to her call.
Can you give him a call, Christine? What's the visiting hours for phone calls on a Saturday at Munroe County Detention Centre? And how much notice do you have to give him?
So she says, "What do you want me to call about? You can't do that on the phone. What can't do what on the phone?"
She was telling me that you can't record it and broadcast it, but apparently, Christine, if you call
your
mobile,
I think what she's saying is I was going to suggest she call in, and she's right. She only has one phone. What we're saying she could do now, I don't know how she's broadcast if she's doing everything through StreamYard.
Yeah.
But does she use her phone for that or a computer? What I was going to suggest was if she's using her computer for StreamYard, she could you could send her the StreamYard link and then she could pop it up on that and have herself like she doesn't even show herself anyways. So we just have the audio there of just listening to the conversation. While we're talking and asking questions, and he might be able to hear us if she's broadcasting. Hold on, buddy. What's up?
Yeah, I think she's actually streaming this live. So, Christine, do you stream your StreamYard on a laptop or a computer, or do you use your phone? Because basically what he's saying is that if you've got StreamYard running on your PC, I can send you the link to come in, and you can call Ty on your mobile, and we can just have him on speakerphone, and as long as you're not showing the picture of him, we can listen to his answers and we can talk to him through you. Right. That makes sense? Okay, so you're StreamYarding on the computer, so you can call him on your mobile then.
Or if it's reverse, if she's calling him on the computer, and then I can give her, she has my number, of my line there, and I can have her just call my phone, and I'll put on speakerphone.
Yep.
I mean, we can do it either way.
The difficult thing is when you set it up, you actually have to put money into his phone account to receive the call as well as having fun.
Well, Christine, if there's a time, I mean, we could probably reconvene this at a different time.
Absolutely,
if you set the call up, we can.
Yep.
Right. So you let us know the time you can set the call up, Christine, and then we can.
There's visiting hours.
Yeah, we can try to reconvene around that.
They do it through the tablet. So you just book an appointment, a scheduled appointment with him, whether it be a phone or a video call, and you pay the relevant cost. But I think it's $10 for 30 minutes video call.
It's ridiculous. Well, listen, everything they do in the jail system is apps. Like you would be shocked at what the cost that they're charging for a bag of chips. And we're not even talking about large chips. We're talking about little like convenience store size chips. They're charging $5 for a bag of chips like that, where we might be paying.
I couldn't even put money into his commissary. They wouldn't let me.
Well, see, that's the thing. I can't get I didn't even know there was a verification of the phone number. Again, like I said, I'll have to try to walk through it. But and then I just I don't know, I just got frustrated with it and thought, well, I guess it's not. I was, it is what it is. Which really we can't, now we have to be aware too, guys, when we do the call, it's being recorded, it will be reviewed. So, nobody can tell Ty what to do on his case, offer any advice to Ty. It's very important because you can get in trouble if you are trying to tell him what to do. So you got to walk that fine line, because that would technically be like we are trying to practice law for him, and we can't tell him go do this, go make this argument. You know, it's why the beauty of the YouTube channel was nice that anybody could, any of these people out here could go put a video up and say, this is what I would do if I was in Ty Tucker's position. I'd file this motion. I'd use this case. But
I put a disclaimer up at the
you
start.
just can't do that. Yeah. Well,
yeah.
Well, and would not stream what, Gabby? Talking to him live, you mean?
Talking to Ty, yeah.
Well, we're making him aware. We'll make sure Christine is aware, and maybe we can do it pre-recorded and then play it up. But
yeah,
you know,
good job, Flash fan.
We're free right now. Yeah, I mean, if you want to do it right now, Christine, we're free right now. Yeah.
You've got to schedule the phone call though, Christine.
Well, it might be he might be available to talk now, like because sometimes you probably have time slots.
Lunchtime on a Saturday.
Yeah. Oh yeah, Saturday. I think because like I said, I've seen the times. I can access the times, but you click it and then it says, "Oh, you can't schedule because you don't have money in your account." And I'm like, I'm going to go fund my account. Yeah. And then I thought I got a code or something, but it still would not let me put the money in. Like it will not register with my bank or something. I don't know. Yeah,
no, I tried the same and it just would flip me straight back to the same option again and wouldn't let me do anything.
Well, UDEF, hey, call.
Yeah, UDEF.
Why do you feel? What is the risks that you think are going to happen? I mean, what are you concerned about? Because a general conversation. I mean, I think Ty needs a voice, and we need to put him in.
Whose exposure, ours or his?
No, but UDEF, we need to have what we're asking him to do is to tell us what happened in court. And we need to broadcast that out. Because that is something that we need to know what happened. We need to know where the motions are at. We need to know what he's being told. And we don't want him to divulge trial strategy, but there's one guy that was in court. No one else was in court. There's unless it was a victim that had a stream, and they get their stream under Marcy's law. So I'm understanding that there is a victim's family that has the stream, but that's under Marcy's law that they get that. We don't have a right to request it. We're not going to be given it. But we're not talking about saying, hey, we're not here to tell Ty, hey, go file this motion, go do this, go get that.
Hey, Mindy. Yeah. It sounds like everyone's had trouble getting money into his account. So, yeah, I was laughing at that. And AJ and I pretty much had a half a stream trying to work out how to pronounce that name.
You'd have hate you.
I think.
You'd have hate you. I think or something. You'd have hate you.
We're over
hate
2 hours, aren't we?
Hate you.
It's who the fuck you think you are, I think.
Oh, is that what it is? Oh, you the F.
Who the F you think you are? Something like that.
Oh, okay. Well, I thought it was saying hate you, but no, maybe that's what it is. No times today. Well, Christine.
So much he won't tell us how to do it now.
Christine, I mean, let us know. I mean, reach out to us. Like, can you schedule one now? Schedule one, and then we'll make sure we're available. Now, tomorrow I have maternity pictures in PA all day. So that is the one day I can't do it. So
belly pics.
Yes, well, the whole family. My son is getting ready to go to college, so we're getting it all done with the whole family, and we're going to do family photos, and then we're going to do the maternity pic. And so, if I told my wife I couldn't show up for that, I'd be divorced.
Christine, can you have a look and see when the next available one is, and let us know? What was I going to say? Well,
UDEF, I don't think that UDEF, I don't think that I don't think there's any possibility he could say something incriminating because he's not guilty. So there's zero he could say incriminating. He testified on the fly with 5 minutes notice in court. Completely confident. Ty's done multiple interviews. He was doing weekly lives. There is no concern on that. The accidental legal advice, that would be something that I would be maybe concerned about. We have to be careful of, but I mean, that's just a simple response.
But
of,
you're aware of that.
I can't answer that, Ty. Well, I just know that Ty's reached out through some channels saying he was like, he needs help with case law and stuff. And I'm like, I can't do that.
Can't do that.
I can, in the past, I provided my own thoughts of of cases I would use by doing a presentation, but I can't.
And he can access that at his own discretion then.
That's correct. And if he wants to use something in that, and I
Monday.
cannot though. Monday's fine. We can do that. Absolutely. Yeah.
Lock it in, Christine.
What time do you want to do it on Monday? We could do it in the morning. I mean, I know that, I know if we're doing it like in the afternoon, poor Jody be up all night.
I don't care. I don't have a wife.
Jody's
I just 4 cats.
I was going to say Jody's almost acclimating to American time now.
I have.
I was going to say you're living.
I did the Ashley Benefield trial like live, real time for the 2 weeks. But I think it took me. I closed off on the Friday. Friday morning about 6 a.m. and I slept right through pretty much until the Monday when I had to be back on trial again.
Oh, I bet, man. Yeah, I mean,
I couldn't sleep.
Yep. I mean, so it's like I said, you would have no jet lag at all if you came over to the States now because you're on our time already.
Yeah, I am. Then AJ keeps saying, "Why are you in chat? You should be asleep." I'm like, "I'm on US time."
Yeah. Now, are there any?
And I'll be doing that too.
Do you have any trials that air over in your country? Are they allowed to have?
They do allow, or they do live.
Well, remember Oscar Pistorius, but that was South Africa. That's not Australia.
It's to live stream or broadcast live stream from the Supreme Court is like getting a getting out account with the jail.
I got you. But harder. I got you. So they don't have anywhere where they're broadcasting it on YouTube or any variation.
No, they do have live stream links on the sites at the courts, but the process to get that
Israel.
That's why you see all the Aussie creators are doing US stuff.
So 1020. Yeah, we can do that. Oh, I did notice that. You're right. Like cited utterance and everybody. Yep. Okay.
They're all covering US because
there's no access. Right. No. Well, see, that's what makes the American justice system unique is because it's meant to be seen.
Why it needs to be televised to be transparent.
And every country needs to do it, but like it's why like a lot of people will say, "Hey, I want to leave America." All these people want to leave America and say, "I'll go live and that's great. It works great until you get arrested for a crime. Check out some of the people internationally who've been picked up and they treat like a possession of marijuana like you're a drug mule and they want to send you away for 65 years. Without any due process, without a proper trial, and they literally convict these people in 14 days or 20 days, and they're sent to some prison, gulag down in the in Antarctica, and that's why the due process clause is the single most important thing. The due process clause is what allows for the whole process that you're seeing unfold to happen. You're allowed due process, and that's
I can go in and watch. But I can't record it.
But you So do you ever go down and watch trials or anything like that? Have you ever done that?
No, because I'm a fair way away from the.
Oh, I got you.
In the city, but we hear on the news they've been arrested and what they're charged for, and then we hear their sentencing. That's it.
And that's Now, what in Australia is the burden of proof on the defendant or the state?
What?
You're not sure.
I know more about American law than I do Australian. I think so, though. Yes, I think it's pretty similar. We don't have the amendment.
Gotcha. Oh, Christine's asking: is 1020 good? 1020 is fine.
Yes.
Yep, we can do 1020 on Monday. Absolutely, for certain.
Yes, and I will get on to you on Facebook after the stream, Christine, for you to give me your bank details and I'll transfer you some money.
You don't want to get, are you saying you don't want to get in trouble, Christine? I don't believe you're
going to. We won't do it live.
Yeah, we won't do it live. We'll record it. We can do a private live between all three of us, talk to Ty.
And then agree on it.
And then we can make sure that, we can report on what he says. Unless Ty is, what I want to know, I want to ask Ty first. That's what I'm getting at. It's are you okay with us putting your audio out? If he's not, it doesn't happen. If he says he is, and then we can double check, I'll go on and double check all protocols.
We can even explain what went on in the conversation. We don't actually have to put his audio out.
But I don't want to,
provided he's okay with that.
I know we definitely can't broadcast any video of the conversation of him, but we could see the video. I think we could put it up privately, so we can have him up on the screen, Christine, and that way we can see him, or whatever, however you're doing it.
I would just do exactly what I did with you, and there'd be 3 people on the screen. That's all.
Yep.
The only difference, but no one else would see it.
No one. Oh yeah, we're not going to go live. It'll be private. So 10:20, and then we can go live afterwards and talk about the conversation.
Well, we can cut it down and edit what needs to be redacted, and then do what we need to do. Yeah.
Yep. Well, I mean, here's the thing: if we can record the audio of the conversation on a medium, like if I could record it on one of my phones, I've got the Google AI on some of my phones, and we could transcribe it. Even
I've got voice recordings. I can record. Yeah, just have my phone on a voice.
We could transcribe the whole thing and just see. I mean, like I said, but we don't want to bum rush them and be like, "Oh, you're live on YouTube, Ty," and then he's like, not ready for it. I don't want him.
He's spoken to you before, hasn't he? So
no, I've never spoken to Ty in person. I've only spoken with Ty. Only. It has only been through Facebook chat that I've ever chatted with Ty, and then Facebook chat, Messenger, whatever you want to call it. And then he's showed up in my lives. And then we've, of course, emailed back, documents and things back and forth that he wanted me to see. But I have never, ever had a phone conversation with him. So this will be the first time he and I will speak.
Neither have I.
Yep.
I feel like I know him, but I don't.
Yep. So we would be able to speak. And I know from understanding, he can be somewhat of a challenge sometimes to speak with. He
gets distracted and waylaid.
Well, he can be, and he can also be rough around the edges too. In terms of like you're not going to convince him to go do X, Y, or Z, and he's going to be But you can. But again, what we want to do is find out from him what happened in the hearing.
I'd also like to let him know that he has got supporters out here.
Well, yeah, and that's why I would like to. What I would like to do maybe is even say, Ty, do you want to do a message to your supporters that we could record?
Yeah, they listen in. They listen in on the phone calls. We won't ask any questions or anything like that that's going to
and here's the other thing too, Christine, you don't even have to play the live for us. We can just be with you there, and we can ask questions and you can tell us what he's saying. I mean, however you're comfortable doing it. But I don't think there's a problem if we're there with you. It would be like if the 3 of us were at your house and you called Ty and all 3 of us talked. There's no provision that says I don't think that can't be the case. I mean, there's people all the time that do it. In fact, there was the Farrader case down there, otherwise known as the boy in a box. And Farrader was talking to his wife from the jail after sentencing. And they were having his kids come on and talk and etc. And family members and all that was going on during that because they were alluding to that during the sentencing hearing. So anyways, but whatever you're comfortable with, if you're not comfortable with it, Christine, we don't have to do it. I'm not like we're not wanting you to do anything you're not comfortable with.
Yeah.
So if you want to set it up, I mean, there's ways to do it. Like you're not going to get in any trouble. I mean, you're not breaking the law by any way. The only thing you might do is the worst they would do to you is restrict your ability to have the calls, because they'd say, but again, if we were broadcasting the live or whatever, that would be a problem.
Christine, I'll get in touch with you after the live stream and go through. And if you want to email me some questions Steve, that you wanted to ask, and I'll put it to her. And
Well, my main question, the only questions I want to ask are what happened in court on Friday.
okay,
What's going on? Like, I would love to just get a rundown from his perspective on what happened.
and he's allowed to give that information.
Oh, of course. Yeah. There's no gag order right now in place. So now if he will say if there is. In other words, he would say, I can't talk to you. But but he could still tell us. It's just we can't broadcast it.
Mm-hmm.
So if he says there's a gag order in place and here's what happened in court, but what happened in court is public record. He just can't. He could tell what happened, but he couldn't give an opinion on it, and we couldn't say Ty Tucker said the judge is an asshole.
Yeah,
violation of gag order.
Hopefully by Monday those documents will be out on file anyway, and we can clarify things or go through it with him even.
Mm-hmm.
It'll give us an idea of what happened.
Like I said, so that however they want to do it. But I mean, if we like I said, what we can do is listen in. It is what it is what it is.
I don't think they've addressed it yet, Flash Fan. I don't think the reinstatement of it. So
So to answer Mindy Ambrose's question, no one knows what happened on Friday. There was no one. There was no one in the courtroom. No. All right, on Friday. So no one knows what happened because the minutes, which is what tells us what happened in the courtroom, it's the closest thing to a trial to a transcript. Mm-hmm. The minutes have not been uploaded yet. They'll probably be up on Monday. It normally takes a day or two.
Documents pending.
Yeah,
be uploaded from Friday.
So they normally in the past when they've had Friday, it's like Monday or Tuesday. They'll pop up on the. Once they pop up, we'll be able to see. We won't know what the arguments were. We won't know the meat and potatoes of anything, but we'll just know that it'll say motion denied, motion for this denied, motion granted.
Oh, really? It won't even say what the motion was for.
Oh no, it'll say what it's for. In fact, each minute, if you look already there, it's telling you what it's for. Motion in limine, motion for emergency. But the emergency motion to dismiss was addressed. I'm assuming it was denied. But the motion in limine will be interesting because some of that might be granted, some of it might be denied, or it all could be denied, or it all could be granted.
One we read through earlier.
But there's several. There was a motion. There's several motion in limines filed by the defense or by the state. Now it also could be that the judge says, "I want to hear more. Like you need to file supplemental material on this issue, and I'm denying on this, but I want supplemental on this." And then that'll pop up on the website in a day or two after Ty writes it. So there's a lot that but we're not going to really know a lot of the specifics that we need to know, which is why talking to Ty is valuable because he can say, "This is what happened in court." And this is what he did, and this is where we're at. You take detailed notes, and then everyone can know. So
we got lots of other great stuff too.
Yeah,
but yes, he's our focus at the moment because his trial's coming up, and we're trying to get as much support as we can from social media and get it out there because I don't know what else to do.
Well, it's funny because this trial, Ty's trial, I was looking back. I didn't realize it, but Ty's trial was the first trial I ever did daily coverage where I aired a daily trial. Yes. Because I started my channel in November and I was just kind of doing I would do daily summaries. It was kind of, I was covering cases, but I wasn't doing daily coverage. I would talk about them. It was kind of just
doing recaps.
Sporadic, doing recaps. And then Ty's case, I remember. I remember it because my wife and I had decided to go to Las Vegas for a few days to before she got far along in her pregnancy, and his trial coincided with that. So I remember listening to it, going through the airport, and then I remember getting in trouble with my wife because because there was a time difference. So I was getting up at 5 a.m. while I was in Las Vegas. I had all my computer equipment set up in the room, and I'm going and broadcasting this thing. And we
you turn your webcam off in between.
Right, yeah. And when we got Well, the nice part about my webcam for privacy measures is I use my phone. So when I like turn my camera off, I just take my phone down, turn it off, and it doesn't connect. So then, like, there's no way that I can even be hot mic. I could be hot mic because my microphone's different, but a video. So I have to be careful on that. There's been times I've left. Like one time I was watching a trial and I stepped away and I left it on and there was kids, a kids show.
I had a stream set up with AJ and I had it set like this. So she was doing a duel and then I was working on the thumbnail. So I minimized the screen because I had it all on the screen ready to go, minimized it, got onto Canva, working away, get this email from AJ. I'm sitting here for 20 minutes watching you like a creeper. She could see me, but I
doing all your stuff
up on the screen.
Oh, that's funny. That's funny. Yeah, you just got to be So, but I remember being in the hotel room. But when we first got down there, I wasn't able to broadcast John Travis Johnson's testimony live because I broadcast the morning session. At that time, I had up to I think it was 6 hours. So I did the morning session and then we were flying out that afternoon. And then I was listening to the testimony on the way to the airport. And then we got to Vegas. And then when I got there that night, we went out, we ate, we did a little gambling. And then I came back and I said, well, I got to go live now with the rest of John Travis. So she's sleeping over there all mad because she's like, we're here to enjoy ourselves. So that's fine. So all night long, I played that. I had listened to most of the testimony. So that I kind of did set it up, ran it. And then I'm sleeping. And I remember waking up randomly hearing John Travis Johnson's testimony. So it was like solidified in my subconscious.
You don't know how many times I've woken up to that.
Yep. And then basically I got up in the morning and followed the case all the way through while we were down there. I got home and it was still going on, but it was the first one I ever gave complete coverage to. So, and then of course, once I got into the case, I'm like, my God, this is like, so it's almost this way in a way, like, I feel like it was like just the way everything lined up. It was just,
it's like your baby.
Yeah. So to me, it's why I said, even when I was considering how I was going to handle my channel if I didn't get monetization, I said, the one trial I will see through to the very end until he's free is this case. So I will be broadcasting. I will be doing everything I can, to get as much attention to it as I can to have it there. And hopefully, like I said, I hope the big wigs take it. I don't care if they accredit me with anything, that's fine. I don't care. This is a bigger issue because the reality is the issue at hand with him is he's going to be locked in a box for the rest of his life. Like this for everyone that's in this right now, for all of us, for me, for all, we walk on in our daily life. We go out, we eat, we have fun, we do this, we do that. Right. For some of us, it's just, hey, something to do. It's entertainment to a degree. Right. But for him, it's real life. Like at the end of the day, when he gets convicted, this is a guy some of us have talked to. We've been around. We've chatted with him. He was free for a while. He was entertaining. He was coming into lives. He and I never got a chance to go live. I regret that because I was kind of a little bit I didn't like I never say we should have people coming on and like him continuing to come on and give full statements. So I was kind of taking the approach like we will have our day where we will come on together when you're acquitted. Like when you've and then we're going to do it. Then we'll have our time to talk and lament and go over. I didn't think he was going to get his bond revoked, but I kind of wish now because you never know. We may never have a chance to ever go live together and talk. But the bottom line is at the end of the day, it's serious, it's real. Like that man's going to be taken out.
Can you imagine if Karen Reed got convicted? The uproar? There is no difference. None.
I know there is. There isn't. I mean, you could see the uproar. She had people outside there to have a whole section cordoned off. Yeah. But the bottom line is like I said with Ty. I mean, it's this is a guy that the thing about it is again, I haven't got into the deep story of my dad's story and everything that goes on, but I think one of the things that resonates with me is the idea that we disregard someone because of a drug addiction. And even if he is an addict, we know he's used drugs. We know there's probably addiction there. But the idea that we say we don't care about you because of that, and we say, well, it's okay for society to dump on you. It's okay for the state of Florida to decide to use you because they want to cover up their own mistakes. And they decide to think, well, you don't matter and no one would care about you. And you're right. Society doesn't tend to care about those people. But, you know, it's how we treat the worst is how we're defined. That's how society's defined. So when we just disregard it, we're all close. We're all closer to getting there than we ever think.
Absolutely.
Homelessness, drug addiction, all of it.
Drug addiction hasn't been an issue for him since he was out on pre-trial. So at least 5 years.
Right.
He's been having random UNA. So that's not even.
Well, the thing is, just to clarify that, we don't want to put out misinformation. He only had his UAs, which is, again, this is what made it also ridiculous. His random urinalysis was only for alcohol.
Alcohol wasn't, sorry.
There was nothing else tested.
But there wasn't even alcohol issues with the case. Like, wasn't included. Like,
I don't even know why the alcohol was included. But I guess it's just they don't want him partaking in that because I don't know. But that was the only thing that he was restricted on. So we don't know what he's ever taken.
Do we actually know he had a drug addiction initially? Or is that
we don't know, but I'm saying people perceive that because he was allegedly the word on hand was that he wasn't using crack. He said he drank Fireball, smoked a little weed, and that's it.
99% of people do.
But the bottom line is, my point is even if he does have an addiction, even if that's present, it is not relevant, because what's relevant is the evidence that proves that he partook in this.
And smoking weed doesn't make him guilty of murder.
Obviously, then you've got states now that have it legalized. I mean, the state next to me, Maryland, it's legal for recreational use. So if you're going to use that standard, you'd have a lot of people that are, which again, that's why in this case, it's like I think that's why he gets disregarded. I think that's why he gets passed over, because the perception is there. But again, what I'm saying is it shouldn't matter. What matters is the injustice that's happening in this case. When you look at the case and you look at the evidence in the case and you look at what they did in this case and you look at how they've conducted this case, it should make people angry, because the concern is like many people say, well, I wouldn't be involved with these people. I wouldn't be. Well, you never know what your circumstances will be.
Correct.
Because I can tell you the homeless guy on the street who's got probably some mental illness, but he never thought probably at one point in his life he'd ever end up there. Right. But it's a couple bad decisions. I would be homeless. It's a couple bad decisions. You know what I mean? It's a couple of things that didn't go your way. It's a couple of bad breaks. Well, when I say bad decisions, I'm talking about decision makings from, maybe I framed it wrong. It's a couple of decisions that didn't go your way. It's a couple of breaks that didn't break your way, and you end up in the situation you're in. But the point of the matter is that a lot of people insulate themselves from that guy or person they see that's homeless on the street by wanting to just act like they're so different than us. And they have to tell the story to themselves that they're different, because that's what makes them think it can't ever happen to me. But it can happen to you. You can become an addict today. You could you could go out to a friend's house tonight. An opiate addict. Yep. And opiate, that's the single most disturbing thing about the whole thing with the opiate thing. People walked into doctor's offices doing the right thing, getting a surgery, and they were told to take pills that developed an addiction, and then they were abandoned by the very doctors that turned them into addicts, who made money off of them when their pharmaceutical reps were coming in. And then those very people ended up in the street because they couldn't get their pills anymore, because they were branded as a pill seeker, and then they were cut off. And then next thing you know, they're going to go get the pills in the street. And then they realize how expensive it is to buy pills in the street. So they tell them, hey, you could go smoke this. You could go inject this. You could go do this. And the person doesn't care anymore because they're addicted. And it's a physical addiction that doesn't get off your back. And then society just says, we're not going to deal with you. Now you're a problem. But the problem is that person did not do anything but do the right thing and was set up for it when it comes to opioid addiction. The point of the matter is it's one choice. So it's one choice. You use something and then it takes over your life, and then your whole life goes down in the tubes. And if we say, well, if you're an addict, we're just going to, you no longer get the Bill of Rights, the Sixth Amendment, the 10th Amendment, the 14th Amendment, the 13th Amendment, 14th Amendment, whatever amendment it is, doesn't apply to you because
before you even get there.
That's horrible. And that's not how we do it. And that's what's happened in the Ty Tucker case, because they've judged him and said he doesn't matter. Well, if you say he doesn't matter, well, you're going to have someone in your life, whether it might never be you, but it'll be a relative, a family member, a child, a friend, someone connected to you one day will find themselves in that position potentially. And if you don't care about, if you let it go by and you say, this is a course of action we're going to adopt and say is okay,
it'll keep happening.
It'll keep happening. So it's at some point we have to say, no, that doesn't matter. What matters is the facts of this case.
I was actually going to do that, Flash Fam. Yes. Did you know Recovery Addicts set up to actually cover? He's got all the setup.
Oh no, I didn't know that.
Live feeds in the courtrum.
But
the Eckhart case.
It strikes me that Recovery Addict covered this case originally.
He did. Yeah.
Yeah. So definitely. I mean, that would be Flash Fan. Definitely. I hope Recovery Addict. Then Recovery Addict has the chops that I don't have and you don't have and none of us have to be able to get down there and get the cameras. Now, where's Recovery Addict based out of? Is he based out of Florida?
South Carolina.
Oh, okay. That's not.
Actually get down there.
So I was going to say, yeah, that's drivable for him.
Yeah.
But yeah, I mean that. So he's actually able to put cameras in the actual courtroom,
and he's got enough for everyone to feed off that feed.
Oh, he does. Wow.
He used to be a cameraman. Yeah. Yep.
Oh, that's awesome.
So much stuff.
No, that's awesome. I didn't know that. I just remember though when the name brought up, I remember him because I think Ty might have even or Lauren, one of them I thought went on the show with him.
Yeah.
Or maybe she was just hanging in his chat, but I remember.
Yep.
Yeah.
Yeah.
Yep.
I've got his email address, so I will reach out to him.
Yeah, that would be phenomenal. I mean, because that's what we need. We need to have
he's lovely.
We need to have somebody get in there. If the big wigs aren't going to go in, if the big wigs are going to go in, then we can still. Well, he doesn't have to go through the trouble of expensive going down there. He can just attach to their feed, but like we all do. But yeah, wow.
Yeah, be amazing.
Well, like I said, it's just we need to get attention to the case. We don't have the resources quite in this situation to put people on the ground because of where it's located at. I just think that is such a problem. Well,
are you far from LA?
Am I? Oh, yes. I am. I'm on the East Coast. My sister lives in LA.
Which county? Like which?
She lives in California. I'm in West Virginia, in the panhandle of West Virginia.
Your mama.
Yep. And I'm in West Virginia, but
Indiana?
No, we're by Washington, D.C. We're in what's called the Eastern Panhandle, and I'm about 50 miles outside of D.C. So we're a suburb of D.C. where we live. We're very much unlike.
What's below that?
What you've got below us is Virginia. Well, Virginia kind of sits there, and then you've got Tennessee is right. Like if you're starting to go south down the eastern seaboard, but Virginia sits between us and the ocean. And then you've got Maryland. Maryland is another ocean area, and then you've got North Carolina that sits. So, but we have to go through Virginia to access any of those states. So we kind of sit on we're like the butt of Virginia.
Yeah, everyone I know is over that, so I can't find this chat on this chart.
That's why they call us. Well, we're West Virginia, but they don't call them East Virginia. But we're literally the western part. Virginia let us go; they didn't want us. But the Panhandle is a lot of the tax base comes out, tax income, or taxable based income comes out of our area because we're so close to DC. So a lot of people come down from DC and live in our area because it's cheaper to live here than
Mm.
say Maryland or Virginia, and we're talking by several $100,000 in terms of a house. So you could buy a house for $300,000 or $400,000 less, but get the same size here and not have to pay the big. And then you've got property taxes are better, et cetera, et cetera. But it's becoming overrun because a lot of people are doing that, and it's kind of one of these deals where, like, at night, it's traffic is horrible. During the day, it's a ghost town. Because everybody's gone.
Yeah.
Nope.
Oh, so they're traveling to work from there. They're like,
Yep. Oh yeah, because we sit literally the way we sit. We are a 15-mile stretch between Maryland and Virginia, and then you have Virginia on the east side of us, and on the west side is Maryland, and then on the other, and then you have a little swath of Maryland, and then you're in Pennsylvania. So I actually take my son to babysitting in Pennsylvania because that's where my wife's from. We have a family friend over there. So I'll travel into Pennsylvania and then be in Maryland. I'll be all around, the whole, can be in 3 or 4 states in a day when I'm out and about doing my business.
Yeah,
So
because Gabby's in Massachusetts and Bry's in Connecticut and AJ's in Indiana. So they're all over that way.
Well, that's why, yeah. I mean, like, I could drive up, like, if it was up north, if Ty's case was up north or something, I could be there. I could be to New Jersey. You can be to New York in 4 hours. You could jump a train and get up there. I could be in Massachusetts, I think, in 5.5 or 6.
Well, they've got flights from Melbourne to LA for $1,000 return at the moment.
Oh, do they? Well, see, you'd have to fly. That's the thing. You would have to fly to LA and then to Florida. Yeah, because see, my brother-in-law, he has family who's in New Zealand and Australia. So the reason why my sister and her husband live in LA, besides the fact that they just like to be out there with the glitz and glamour, is because it's easier for him to get home when he wants to go, because they go home to Australia, but it's kind of a dual trip. They'll go to New Zealand to visit, because I think his mom still lives in New Zealand and his dad lives in Australia. So they fly into Australia first, I think. Would that be the right one? No, New Zealand first. Okay.
Yeah.
They go to one of the two first, and then they fly to the other one, and then they come back, and then they go home. But it's a long flight. I know that.
17 hours or something like that.
Oh yeah. Their kids have done it every year since they've been born. From the moment we're talking 4 months old, it's time to go home, and they're throwing them on the flight, and wherever they go. They've offered, like, of course, I have 4 kids and my wife, but they've always been, if you want, always tried to invite us out to go meet, his family and go out there, but it's just expensive.
Which state in Australia? Yeah, that's why $1,000 is cheap.
I am not certain. I want to say, I am not certain. I'd have to ask them. I want to say, oh God.
Hot or cold?
What is it? What's that?
Is it hot or cold temperament?
It's hot.
Queensland, then.
It's Queensland. Yes, that's it. Yeah. Okay. They're Queensland. Because, and they've said, you come over and, it'll be a, fun time. We're set it all up. You can see my wife's always wanted to go to New Zealand, and like, you can come over and visit.
New Zealand's beautiful.
And, but like I said, it's also very, like, when we look at it, we're like, that is a lot of money just to get over there. And for us, we got to fly to LA and then go over. So it's like, maybe when the kids are,
Well, that's where you go and stay with people that you know.
that's what they're offering to us, was like, you can come stay with us. All you'd have to do is the airfare. You don't have to worry about hotels or nothing, because we'd put you up and you'd be able to, enjoy and check things out, but it's.
Well, I can fly to LA and everyone can meet me there.
Yeah.
And we'll have a YouTube reunion.
There you go. Well, I mean, I think one of the things that they do sometimes, and maybe at some point Ty Tucker will be invited to Crime Con or something like that. If he were to get acquitted, I think he would be at that legendary status as being a pro se defendant. But you could come over for Crime Con, I think I don't know. I think they do it. Yeah, it happens yearly, but I think they move the location all around. So maybe one year, if that's in LA, one year, that's the year you could come over.
Yeah.
Yeah. And then, like I said, I have my sister has a house over there. So if it's in LA, I can go out there and stay with her. She's been wanting me to come out. We haven't got to see her new house. So it would give us a reason to get out there. But yeah, that just happened. I think that was in May or June. I can't remember.
Yeah, I think Emily D. Baker went, and so did
Yep.
Yeah,
Yep.
Yeah.
So
I've sent all of my this stuff to them.
Well, like I said, I think it's a case that they will cover when
the time comes.
When the time comes, but I don't think at this point it's like for them it's the optics of Ty and the baggage that he brings to the table. So
you're right.
Yeah.
You gotta go.
Yeah, actually I was just looking out there. Yeah, I realized the time. So because I gotta be somewhere. I'm supposed to be somewhere at 1:00 and I just realized it's 12:52. I lost track of time.
Funny how that happens. Yeah.
Oh, well, that's why I can go. Like, I'll get on a stream and I'll be like, I'm going to go. Like the other night, I got in trouble because I was doing a stream.
Just pop on for an hour.
Well, that's what I told my wife. I said I'm going to go on, and it was late. I wasn't going to do it because it was getting late. And I'm like, I would like to have more people in, but it got late. And I said, well, I'm just going to go on for an hour. I want to run this sentencing hearing down. I'm not even going to play the whole hearing. And then I don't even know if it could be heard in the stream, but about 1 a.m., my wife comes out and is like, you said an hour. What? And I'm like, so, then the next day she was like, what are you doing? And I was like, I'm sorry. So, I just get on there.
AJ, it's 3:00. I got to go.
Yep. It's just easy to get on here and just go,
Well, it's nearly 3 a.m. here. So,
yep. So, well, then I guess let me know. Keep me apprised. Christine, keep us apprised. I mean, if you don't feel comfortable doing it, that's fine. And then,
already, so I'll get in contact with them.
And then I was going to say, find out even if it's just a rundown what he says, we could maybe try to hook up again to do a live at some point and then go from there.
I will be in touch. I have your digits.
Yes. And then we will, go from there. And then, like I said, we've got another hearing coming up on the 12th, so we'll see what happens.
Yes.
And see where everything goes.
Yeah, and then we're only 3 weeks out.
Well, again, like I said, but we don't know. I'm hopeful we will get the opportunity to cover the trial. I mean, I want to fingers crossed. I can't imagine they turn down a story like this. You got a pro se defendant. Why the hell not? But
email RA tonight.
Yep. So, all right. Well, I guess I'm gonna exit. I guess I don't know why my mouse won't work. Yep. So do you want to remove me or do I need to remove myself?
I'll shut you down. Yep, that's
I was
fine.
gonna say,
Thank
okay.
you so much for being here and joining us. I know your plate is so full, and you've clarified a lot.
Well, yeah, because that's the other thing too, Jody, is it's potential. As I was telling you earlier, we'll see how things evolve today, but if for some reason I'm not available to be around Monday due to a baby coming, I'll let you know. But hopefully,
no worries. So don't forget to head over to Justice is a Process and like and subscribe to his channel. The link is right there for you. And I will, once you've gone, I will put up all of your other links as well. And
appreciate it.
Yeah.
Thank you for having me.
Joining us. You're welcome. Very, very welcome. And give your wife a big hug and kiss.
I will. Holy crap. We're having a thunderstorm. I don't know if y'all heard that thunder. Woo!
Yeah, I did.
Anyways, I know. I was like, holy. Well, my dog right now, when the thunder comes, he's under the chair over here. Yeah, he doesn't come out for that. That scares me. But So
thank you very much again.
Yep, no problem.
I'll be in touch.
Thank you guys. Yep. See you later. All right. Good deal. Yep. Bye-bye.
All right. Wow. There you go. We finally pinned him down and got some info out of him, which is really good because he clarified quite a lot for me. There was a lot of those motions and notices that I read through and just had no idea what they meant and what implications they had. So And I've just checked the Monroe County Sheriff's Office Clerk of Courts again to see if any documents have been released, and no. So I doubt we'll see anything on there before Monday, maybe even Tuesday at this point. So nobody knows what's gone on, what motions were heard. They weren't all addressed because, as Steve said, there is another hearing on the 12th to address the remainder of them. And yeah, we go from there. But the upshot of it all is that Ty is staying as a pro se defendant. He was offered 2 public defenders who had to withdraw due to conflict of interests. And then he was offered a private investigator attorney, and he declined. So, but he applied for Indigenous status. So he now has access to the tools that he needs. So he's got access to computers and pens and papers and what have you. So he can start, emailing subpoenas and doing the stuff that he needs to do. Because when you're a pro se defendant, you are expected to provide your own resources, basically. And that included pens and paper. They weren't providing him with anything. So, see you, Flash fan. Thank you for joining us. And yes, the more you bombard Court TV and Law and Crime and apparently even the Department of Justice, you can contact them as well. You can email them. I'm going to try and put together a whole list of, actually, let me see if I've got a list of his contact details. Just so that you know, where are we? Like all of his Facebook pages, his YouTube pages, his, I know I've got it somewhere. Probation via no, intent to be no. Motion to return property. Motion for court reporter. No. I will find it. And if I don't find it, I will put another one together because I've got it saved somewhere. I know I have. It's just a matter of looking for it. So there we go. You may get banned for law and crime. Got to. Yeah. It's really sad because there's so many the comparisons between Ty, of the level of injustice between Karen Reid and Ty is equivalent. And thankfully she has money to have these high paid attorneys, defense attorneys for her. Where would she be if she had a public defender or no representation? And I think also, as Steve said, the impressions, people, like at Ty's first trial, a lot of people even judged him as being guilty just purely based on his appearance and the way he spoke in court. You can't make those assumptions of guilt or innocence or rights to a fair trial based on anything like that. And everyone is entitled to a fair trial. Everyone, regardless of where you've come from and where you've been. That's the whole point of the system. And it's supposed to be transparent. And the fact that, any hearing since April of this year that involves Ty Tucker is not being released to the public at all. Not even audio, nothing. And as Steve said, you get the transcript you get the court minutes, and it doesn't give you any information whatsoever on what was discussed. So the only thing you can do is read between the lines in all the motions that they put in and all the paperwork and the documentation. And yeah, no one likes to speculate. But there is he is 100% factually innocent, exactly like Karen Reid. That, so there was no, like, as far as Karen goes, no DNA evidence on the car, no DNA evidence on the taillights, no physical evidence whatsoever, no crime scene evidence, no digital IT evidence, nothing. Exactly the same with Ty. The knife did not have any of his DNA on it. Crime scene didn't have any DNA on it. The getaway car, none of his DNA in there. Nothing. Nothing tied him there. The only thing that connects him is his association with the co-defendant, John Travis Johnson. And had he not recharged his phone that day and walked down to the phone place with John Travis Johnson, he would not be in this position he is in now. Simple as that. That's it. And, he's not a young, beautiful woman and doesn't generate the, or apparently doesn't warrant the same exposure. There's no one out there protesting at the front of the courtroom for the injustice for Ty. There's no one out there creating defence account funds and stuff for Ty. There's no one. You may not like his personality. You may not like his attitude. You may not like the way he goes about things. Don't make him guilty. Don't make him guilty. He's still entitled the right of a fair trial at the end of the day. And I hope that he honestly gets one, because otherwise the system is flawed. Why should the Canton police be held accountable, and the Canton PD and the state troopers and the DA, but not the Key West? Because they're all doing the same thing, all of them. They're all covering each other's ass, each and every one of them. Witness tampering, evidence tampering, tying his hands with legal motions and, gag orders and then literally, who else have you heard? Like, anyone who else watches the daily dockets of judges and stuff. I watch Judge Boyd, I watch Judge Fleischer, I watch Judge Wolf. People come in with parole violations, and they get a couple of warnings generally. Okay, you didn't charge your ankle monitor. Okay, that's fine. You've got a warning now. You need to do this. You won't get another offer. Yeah. All right. Well, you missed this. You need to do that. You haven't done this parenting course. You need to get this sorted. They at least get some kind of, slap on the wrist, and that's your warning. Sort your shit out. Get it done. He's late for a random U&A screen. And not only did he have an immediate bench warrant put out for that, his bond was set at $3.1 million for it. He'd been out on pre-trial release for 5 years prior to that with the ankle monitor on. But he opened his mouth on YouTube and they want to shut him up. Absolutely. The district attorney, if you saw it, Colleen Dunn has been suspended from the Florida bar twice, and they've just rehired her again. She's the district attorney down there. She was suspended for 15 months because she had an involvement in putting a jailhouse snitch into the same cell with Ty to elicit evidence, stories. And the story that he came out with was he got all of his information wrong, and his testimony basically included Lauren, which was Ty's wife at the time, and had nothing to do with the case at all. So it was thrown away because it was all BS. but she was found to have a hand in placing him there to try and elicit testimony against him. So she was suspended for 15 months, and she's been put back there. They've rehired her. The judge recused himself at the end of the first trial. And we get a new judge who we think has a fresh pair of eyes. Well, lo and behold, he is the protege of Mark John James Jones, who was the judge that nominated him for the judicial position and actually presented it to him. Did the official, I can't remember what it's called, but yeah. So, and not only that, but Judge, who's the current one? Jones, Morgan. Judge Morgan has an army background, so he's going to be way more strict on everything and to the book. Like, I actually think he's going to be harder, and he's proved it because of the bench warrant, harder on him than Judge Jones was. So he's pushing it up a hill at the moment, big time. So the thing that makes me upset is Mansfield used to be a firmer. Yes, he was. Yes, yep. Yes. But you see, they're covering their asses because Ty knows too much about them. He knows, and he's got the evidence. You go onto Ty's, it's free Franklin Tucker on YouTube. He has all of the body cam footages. He has interviews, police interviews. He has heaps of documents. He has the lead, one of the investigators, Penny Phelps, one of the main investigators, her internal affairs report, because they generated an internal affair investigation on her conduct through this. And the list goes on. It is so similar to Karen. It's not funny. It is not funny. And yet the polls could not be further apart as far as support. Yes, we are, Christine. Yes, 10:20. I will, once I finish this stream, I will contact you back on Facebook Messenger and have a chat to you. I won't be too long. Thank you. So yeah, it's really scary and it's really sad, and I don't like it. I don't like it at all. And it comes on the heels of, Ashley Benefield. I do not know how that jury could convict that woman at all. I have no clue whatsoever. And yeah, I might actually do a bit of a I might do a stream on DV just to make people aware that not all DV is physical, and what signs you can look out for, because someone you may know may be experiencing that, and they look at Ashley Benefield. How many people are going to think twice now before coming forward because of that ruling? It's a massive setback for DV sufferers and survivors. Massive, because they're going to think, well, they didn't do anything to help her. They're not going to do anything to help me. So why should I come forward? Why? So, but all the information on his YouTube channel, it's original. It's there for you to research. Gavel drops on Discord. I'll put up their link now. They have more documentation, so they cover. If you search on his name, they have a link, and that link has a thread, and that thread goes right back. So any media coverage, newspaper, all these trials, the documentations, document dumps, like everything that you need for Ty Tucker, you'll find it on there. They are amazing. So go and check them out, and especially if you want to do research for yourself on anything else, they are the place to go. They've got so much material there. The girls work so hard. Well, I think they're just, sorry, that's probably a generalization. The community there does an amazing job, and they're really supportive of helping you set up and supporting your own Discord channels as well. So head on over. They're amazing. All right. Well, I'll put this up again for Steve. Justice is a process. So he has a Cash App link. He has a Buy Me a Coffee link and a Buy Me a Coffee link. And I have linked it to those headings. So you should be able to just click on there and it will take you to those particular sites directly. And he is remonetized on YouTube, so you can send him super stickers and Snapchats. What do you call them? I can't remember. super chats and I can't remember. It's 3 a.m. I got to go to bed. All right. Well, that's done there. So I'm glad we got to go through some of those documents. Hopefully, we will have some more updates next week. I'll take that off now. So a big shout out again to Steve. Thank you very much for joining us. He is a very, very busy man. He's got so many things happening. Super chats. Thank you. Yeah. So many things happening at the moment. The poor bugger. So we were very, very lucky to have grabbed him. And he doesn't do, he doesn't collaborate on other creators' channels at all. So we are very, very privileged. All right. So with that, I hope everyone has had, has been updated and has had some clarity on any questions as far as Ty goes. So, yeah, bombard every true crime creator you can think of and ask them to get behind him, start promoting his case. That would be awesome. We can start generating some traction and getting his cause out there. All right. And you are welcome to share this video with anybody. You can share pieces of it. You can share all of it. You can do what you like. You have my permission and Steve's to get that message out there. All right. Oh, look, he's amazing. He is just the most amazing. He is generous, kind, honest. I don't even think I could imagine him getting angry. There's not a mean bone in his body. He is super encouraging and helpful, you know, to the smaller people as well. And I can't say a bad word about him. But nothing bad. He's lovely. He is the reason I started my channel, basically. And I had the privilege of joining him on stream very early on when I just opened my channel. So it was lovely. And he's been so supportive ever since. Been really, really good. All right. I shall sign off and I will keep your notification bell on because there could be an impromptu live coming depending on how things pan out over the next 3 or 4 days. So, yeah, click that bell to all. Don't forget to like and subscribe. It really does help push the information out into the algorithm and it does help the channel. I'm still working on getting up to meeting the criteria for monetization. I've only got a couple of hundred more subs to go and we're there. So it would be amazing if you could just click that like and sub for me and push me over that threshold and it would be it would make my year, absolutely make my year. And it doesn't mean I'm going to bombard you with anything. It's like putting you on, like clicking your favorites list. That's it. It costs nothing. It's no commitment, no obligations. That's it. Done. 2 seconds. Boop. All right. With that, good night, all. Thank you for being here, and I shall bid you adieu.
We had a blast again. Steve and Jody on the screen, living out our dream. Justice is a process, every episode you see. Defense rests silently, hope you agree with me. Oh, like and subscribe, join us for the ride. Hit that button now, make us extra proud. Every like matters, every sub counts. Your support uplifts us, higher we bounce.